What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God!
Everything that guy just said is bullshit. Thank you.
Thank you. Oh, we got a lot of light coming in the room here today. Geez, we'll have to turn down the brightness here a little bit when we get going. But good morning, good afternoon, good evening, good night, everybody, wherever you are, whatever you're doing, all that other stuff we usually say. We got to cut straight to the chase here because there's a lot to get through here. We got to get through the afternoon session of the hearing, the YNW MELLY hearing, the motion hearing that was just one of many, many things we had planned to do. I got to keep these time frames. I'm in South Korea here, so it's morning. It's 11:04 a.m. here, so the stream was my last night, but the U.S. is morning, and now it's my morning, and it's the U.S.'s yesterday night for me. So I got to keep these straight in my head. Yesterday morning stream was supposed to be just full of YNW MELLY trial updates and a little bit of Bortland spiced in there as well. But it turns out that this motion hearing that there's going to be like the last thing we discussed became a hearing. And when I say hearing, it's not the usual. All right, I've read your briefs. I've read the motion. Do you have anything you want to add? No. Okay, well, I'm going to make my ruling, and this is my ruling. This has turned into a whole damn thing, a whole day hearing. And it's intense. There's two things going on here. There's the motion to recuse the entire district attorney's office from hearing this case. They're saying it's a problem, and what they're alleging, and apparently it's not an allegation because they got one of the prosecutors to flip, and she testified in the morning. So you have to go back and watch the last stream I did to get her testimony. She's sort of like the internal affairs for prosecutors. She investigates prosecutorial misconduct in the DA's office and prosecutes it and works on it. She testified at this motion hearing for the defense. So what's all of this about? In a very, I mean, it was 3 hours of insanity is what it was. So I got to distill this down as briefly as possible. There's a motion out there, a motion to dismiss that is based on this apparent illegal search warrant being issued against YNW's MELLY's mother, Ms. King, for her cell phone. Apparently there was the lead investigator, Moretti, the lead guy, the guy that was the star witness for the prosecution during the first trial. He executed an illegal search warrant, which he knew was illegal at the time. I don't even think we have to say allegedly, because hell, it's pretty bad. There was two other people in the room. The other officer, there was another officer that was not in the room. It is factually indisputable that this guy was not in the room at the time. Why is that important? Because the prosecutor said, if you are the lead detective in her presence essentially said, you need to testify that you were in the room when I served that. And the other officer responded, well, if I'll be wherever you needed me to be. So the prosecutor that is now testifying for the defense, she testified under oath that the lead investigator in the YNW MELLY case conspired with another police officer to falsify an affidavit regarding the service of the search warrant on YNW MELLY's mother. That's a huge thing. And not only did she say that, yes, he said this, and yes, he solicited another officer to falsify a sworn statement, but she said that she also reported it immediately to her superiors in the state's attorney office there for Broward County. And they all knew about this illegal search of her phone, of YNW Melly mother's phone. They knew of the lead investigator's improper and frankly illegal acts before the trial started. They sat on it for 11 months during the entire trial. And only a couple of weeks ago did the defense find out about this. And they immediately talked to her and she confirmed it. And she also said that in addition to all of these things that she told her superiors about, she formally in a letter to her superiors, and also she testified yesterday under oath that she informed them that under no circumstances would she ever work on another case with this lead detective Moretti, because he has already made it clear that he is willing to falsify evidence against a defendant who is facing the death penalty in a capital murder case. So she said on the record and under oath in court and in a letter to her superiors that she's not ever going to work with this lead detective again. This is huge. This is huge news. And the new defense lawyer, the new defense lawyers for Melly, they've still got Raven Liberty, the giant vampire chick. She's still there. And the small angry white dude, he's there. And then they've got two other new guys. There's one guy that's handling this motion hearing. He is on fire. He was coming after the judge. He was getting after the judge, and the judge was getting defensive. One of my favorite exchanges was, the judge was sitting here listening, and the defense lawyer says, "Now, Judge, look, I can tell by the way you're sitting there with your arms crossed, smirking at me, that you think the defense has done something wrong in this case." And he went after the judge, and the judge said, he said, "Look, I am taking this very seriously." And then it came to light that the two people that were the subject of this motion, the lead prosecutor, Bradley, the female lead prosecutor, Bradley, and the woman that was testifying for the defense, they weren't there at the hearing. They were the subject of this hearing, and they weren't there. The prosecution didn't bring them there, and the judge was pissed. The judge was pissed about that. Well, the one that was going to testify for the defense, she was there. I'm sorry, I correct myself. It was Bradley, the lead female prosecutor on the case. She wasn't there when she was the subject of this. The judge went nuts, and he literally did yell at the prosecutors and said, "We're going to take a break. You're going to get her on the phone, and I want her here." And sure enough, by the end of the break, she was there. Judge was pissed. The judge chewed her out. This is gone wild. I thought this would be a 30-minute hearing. It's turned into a whole damn day, so I could only watch it up to the lunch hour. And they took the lunch break, and I had to call it quits. Got 4 hours sleep, woke up. I've already done two streams on other people's channels today, and then we've got this. So there's about 2 hours and 15 minutes of this left. I think there's a break in there, so it's probably 2 hours. And that's where we are. If we have enough time at the end, we'll go back and we'll look at this other motion, this motion to dismiss the entire hearing based on, the entire charges, dismiss all of the charges with prejudice based on the actions of Detective Moretti and the evil fruits of this search warrant. Before we jump into this, Jenkins with a $5 White Rabbit super chat. Jeebus, I missed this morning. Now I feel like I need to go watch part 1 before I can watch part 2. Part 1 was the one lady that flipped. Now on the stand after the lunch break, if it goes the way I think it goes, the lead prosecutor, the woman that prosecuted YNW Melly, is going to be on the stand, grilled by the defense lawyer about this. And just so you know, the reason they're saying the entire prosecution's office needs to be dismissed, why the defense is arguing that, is one, the woman that basically is ratting everybody out, which is her job. Good on her. She's obviously going to be, they said, if they call Moretti, the lead detective in this case cannot be called as a witness by the prosecution without looking like a horrible, horrible person, because they're going to put the lead detective, sounds like the lead attorney, the lead detective on the scene, on the stand. He's going to give his all of his reasons why all of this stuff happened and why YNW Melly is guilty and what all the evidence showed. He's going to say, oh, the evidence showed all of this. That's why he's guilty. And then the defense is going to get up, and their first question should be, have you ever encouraged another officer to falsify evidence, lie under oath? Clearly, the answer is yes. But of course, his defense to that was, well, I was just joking. I didn't really want him to come and falsify this statement and say that he was in the room when he wasn't. It was jokes. It was witty banter. That was his defense, and nobody's buying it. And then the second question should be, isn't it true that someone in the prosecutor's office, the very people that are sitting over here on this bench prosecuting this man, some of them have said that under no circumstances will they ever work with you because you are willing to falsify evidence in a capital murder case? Who's going to believe a damn word that comes out of that guy's mouth? I mean, this is almost making Mark Furman in the O.J. Simpson trial look like amateur hour. This is bad because not only is it calling this case into question, every other investigation that guy has been involved in automatically gets called into question. Has he done this before? This certainly isn't his first time doing this. So this lady has to be excused because she's going to be a witness. They said, if you put him on the stand, we are definitely calling this prosecutor as a witness. And because the lead prosecutor, the lead prosecuting woman who's going to be on the stand here, she knew about this. So they said they're going to call her as a witness as well. And she reported up the chain of command. She reported all of these improper behavior, and they did nothing. So he's essentially said that they are going to call all of the prosecutors, all of the lead prosecutors, all of the higher up prosecutors in the Broward County State District Attorney's Office as witnesses in this case. Therefore, the entire office has to be excluded. That's what they're arguing. Yeah, KT says that's what I think. Moretti really fermented this case. This is going to be rough. Well, let's jump into this. Let's jump into the afternoon session. I hope that gives everybody a better idea, better understanding of what's going on here. All the confusion. If you want some clarification, go back and check out the morning stream. And all right, let's jump into this, and I'll fix the focus and the brightness on the camera here, and we'll all live happily ever after. How does that sound? All right, bring it on up. There we go. This is coming back. And again, who better to talk about and pontificate and comment on the alleged murder by a young black rap artist than a fat old white cowboy from Utah living in Korea? Nobody, frankly. It's me. I'm the best person there is. All right, law and crime, take us into the afternoon session. This should be the end. Yep. They start midstream. Of course, they can't start properly and on time. So here we are. Yes, she is on the stand. Good for her. Lead prosecutor, Ms. Bradley, is being questioned.
It was in the BSO deputy's report. The only thing that mentioned in the conversation between the two of them was in the BSO deputy's report.
Great. No closed captions available yet.
Did you ever reach out to Deputy Gore?
I did not. He actually approached me for the first time last week.
Okay. And what did he tell you?
That the recollection and whatever he said at that time, that there was no request for anyone to lie or anything to that nature.
No request to lie. Sure.
But, okay, let's go back to it. So, Detective Moretti, you know that Ms. Boutros is never going to work with Detective Moretti again and call him slimy and untrustworthy.
Correct.
Sustained. Rephrase your question.
When you find that out, you talk to Detective Moretti, correct? You just told us.
I asked him to write a report. I did not speak anything about what Ms. Boutros said to me or anything of that nature.
And Ms. Boutros, she was the lawyer that testified in the morning, the prosecutor that testified in the morning that we were talking about. And you can already see the difference in their attitudes. You can already see that Bradley here is being very standoffish. She's being a little bit arrogant. She's getting just drug across the coals here. Yeah, prosecutors don't like to be questioned whatsoever. The last lady that testified in the morning, she was very eager to testify and to clear her name and to say, hey, look, I did everything to get out of this. Now I have to do this silly thing here. So the stupid focus lens camera place thing here is going to come up and then it's going to look stupid for a few minutes. So bear with me while maybe we don't have to do it. Cool. Hey, we avoided the focus box. All right. So yeah, let's look at this some more. She's being a little hedgy, little arrogant, little standoffish, because the other lawyer in the morning said she knew about this. She knew about it from day one and still went forward with it.
Sure. Okay. What's the next thing you do on this as far as this statement?
In terms of after his report is issued?
Well, as far as the incident that occurred in which Ms. Boutros is claiming that he was soliciting Deputy Goral to lie, what's the next thing that you do after, I guess it's 5 days later, 7 days later after this occurs? You talk to Brady. What happens next?
After I got his report, it made no indication about any request to lie or to have.
Okay, so she gets Moretti's report of Moretti's interview, and surprise, Moretti didn't put in his report that he asked another police officer to lie for him. Come on, woman, why do you think Moretti would put that in a report?
BSO say that they were there when they were
Come
not.
on.
I at some point reviewed parts of this statement. I had requested copies from the sheriff's office to preserve any and all surveillance that existed to see on timeframes as to anything that had happened.
Did you talk to Ms. Boutros about it?
No, the only conversation I had with her was on October 17th when she called me. She does not come into the office on a regular basis. It's my understanding she works remotely.
Okay. So
Why is she got to be a snot like that?
Detective Moretti, as far as what he actually said on that statement, or did you question him at some later date of that?
At some later date, I couldn't tell you exactly when.
Can you give us a rough estimate?
I could not.
Was it before?
Ashley Oaks has said, are we missing beginning of her on the stand? Yes, they didn't show that because law and crime. Yeah, they just jumped in somewhere in the middle of it. I don't know if she's been on the stand for 5 minutes or 2 hours. It wouldn't be 2 hours. They were still on break. But yeah, they chopped out the first part of her testimony. Thanks, law and crime.
Or after the last trial?
Before.
And do you know who was around when the internal affairs investigation was over? Was it before that?
It was before that.
Did you have any input in the internal affairs investigation?
None at all. In fact, I only became aware of it when Mr. Edelstein told me that it was ongoing.
You didn't talk to the AI sergeant?
IA sergeant, perhaps you mean?
Whatever.
So once I became aware that.
I don't like that. The AI, you mean the IA? Yeah, whatever, Bish. You know what the fuck I'm talking about. Knock it off and answer the damn question. Just whatever. Not good. I like this lawyer.
There was an investigation.
I like him a
I
lot.
contacted the Miramar Police Department to find out the status of the complaint because my understanding it was never elevated to an actual investigation because they found it without merit. And I said, I have a copy of the surveillance footage from that. If there's anything that you need and I can provide.
Surveillance footage?
Now,
all right, I'm interested in
you
surveillance
spoke to
footage.
Detective Moretti prior to the IA report being concluded.
Yes.
And you don't know exactly when, but you know it was before.
Inherit the Wind,
That's
great movie.
And the subject of that conversation dealt with the allegations against him as far as trying to get Deputy Goral to lie.
Yes.
Tell me about that conversation.
The best record of what was said is what was filed in the, I believe, August 23rd, September 23rd, Brady notice, in which is the first one that I filed that I drafted on with regards to what was said.
Okay, so the IA investigation is done basically around July 20th of 2022.
I don't know the dates on that one, my apologies. I was not expecting to testify today, so I didn't review.
Is it a fair statement to say numerous months went by between the time you talked to Detective Moretti and you issued that Brady notice that you said on September 23rd?
That is correct.
Okay, do you know how many months?
I do not.
did the trials go on in between those two times, meaning the first part?
It did.
Excuse me? So yes, she's just saying that they knew there was an internal affairs investigation going on about this Officer Moretti, and they still went ahead with the trial, knowing that their lead witness was under an internal affairs investigation. And they didn't bother to tell anybody else that. And you'll notice, some of you were mentioning that he's leaning on the lectern when he's talking. That is a confident status of someone who knows they are going to be crushing this witness. I mean, we've seen it a lot in the O.J. Simpson trial that I cover every Thursday, when you have Barry Scheck cross-examining Dennis Fung, the LA criminologist, on his shenanigans and misbehaviors. It's just that leaning on the stand, knowing you are calm, you are relaxed, and you are going to just crucify the person on the stand. So yeah, he's enjoying his position. And we got a couple of things here to point out. Heather Sparrow says, did you watch the Law and Crime interview with his ex-girlfriend and her mom and their lawyer? A lot of tea about Moretti and Bradley antics. Yeah, see, I was planning on watching that. It's about, I can't remember how long it is, about 30 minutes long, I think it is. We were going to watch that as part of my show this morning, but then we just got into this whole thing, and that's where we are. We'll go back and we'll do it next week, probably on, I don't know, Tuesday or Wednesday or something. We'll work it out. But yeah, we got to get on this. We'll watch that. We'll do the other updates that I was planning on doing but didn't get to because of this. And the Law Lounge with Law Lady. What's up, Law Lady? A new member. Thank you so much. Thank you so much for being the newest member of the Clean and Sober crew. And Hempland, Texas, Hempland TX has gifted 10 Legal Vices memberships. If you were one of those lucky few who got a Legal Vices gifted membership from Hempland, Texas, give her a super, super special thanks for her generosity and her donations. Let's keep it rolling.
It did.
Okay. So you had talked to Moretti about the allegations of his trying to get a deputy to lie prior to the first trial, but you did not reveal that in any Brady notice.
So the discussions were that he denied that any such conversation took place, that no such event happened.
That doesn't matter. Of course he's going to deny it.
I'm paraphrasing on this one. I'm paraphrasing, but he stated that the deputy showed up. He didn't even know who it was, and the deputy was lost. So there was about 5 or 6 minutes in between when the sergeant had left before the deputy showed up. At that point, when the deputy showed up, Detective Moretti asked him something to the effect of, were you outside when this all happened?
Outside?
Yes, when this all happened. Detective Gorell replied something to the effect of, I can be if you needed me to. Basically, Detective Gorell, if you reviewed the surveillance footage, went to the wrong conference room and was on his phone wandering about the 7th floor trying to find him.
That was all.
Look at that little smirk there. Come on. See, this is the thing. And again, I know I've ranted about this so many times, but it is so fundamentally important. People are like, well, okay, so how does this prove Melly didn't kill them? Melly doesn't have to prove shit. He doesn't have to prove he didn't do shit. He doesn't have to say a thing. His defense lawyers don't have to do a thing. The burden is on the state. The state of Florida is literally trying to kill YNW Melly legally. They are trying to put him to death. Not just put him in jail for a few years. They're trying to put this man to death. Their burden is to prove fairly and justly and in conformity with his rights under the Constitution of the United States that he is guilty beyond a reasonable doubt. And when you have the lead detective saying that testifying that he was somewhere and something happened that didn't happen, that he is soliciting someone to lie and falsify a statement, and then the prosecution doesn't tell the defense that this happened. How is that a fair process? How can you trust anything the prosecutors say? How can you trust anything, any investigation that this police officer has done when he has demonstrated on camera, apparently, that he may have asked someone to falsify evidence? Carlos 247 says sounds a bit serious when you put it like that. It is. This is literally the state has the power to kill you. They have the power to kill you. And you better damn well do it fairly if you want to take someone's life away. And they said, you know, this is the Brady violation. The Brady violation again is the prosecution has a duty, and absolutely they don't even have to be asked to do it. They have an affirmative duty to turn over to the defense any evidence that will show that doesn't have to show, that may show or may provide the grounds for arguing that the defendant did not do the crime. Anything that will exculpatory evidence, you know, evidence favorable to the defense. They have an affirmative duty to turn that over. Now, why is it? This isn't evidence that would get Melly off the hook. This isn't evidence saying that someone else did it. This isn't evidence saying that he wasn't there. Why is this a Brady violation? Because not only do you have to turn over evidence that is favorable to the defendant, they have an affirmative duty to also tell about circumstances that may affect the credibility of their witnesses. They have a duty to tell the defense. The prosecutors have an absolute duty to tell the defense, hey, this guy that filed, you know, the lead investigator that got the search warrants, that conducted the investigation and is going to be testifying on the stand, they have a duty to say that that guy is under an internal affairs investigation for fabricating evidence. They have an absolute duty to do that without being asked. And not only did they not do that, the defense lawyers asked for any Brady related information that we don't already have. Please give it to us. And they still didn't do it. And that's why they're asking for this to be dismissed, the entire case to be dismissed. And if not, they're asking that all the prosecutors be taken off the case. I know I've been saying this since the morning stream. This is serious shit we're dealing with here. This has gone off the rails. Exactly, Manders, in their case. This isn't just a guy who's saying that, this officer's under internal affairs for improper conduct or misconduct in investigating a different case. He's literally being investigated by internal affairs for screwing around on this case. They didn't tell the defense. And this is what he's talking about now. And this is why she's got this dumbass smirk on her face. Well, we asked him and he said he didn't, he said he didn't falsify it. Why the fuck would he put in his report? I asked the officer to lie and say he was in the room at the time. So that's how we got. Why is he going to put that in his report? That is just so disingenuous and scummy and slimy. And that smirk.
Well, but my question really is, you had a discussion with him that he was being accused of trying to get an officer to lie, and this was months before the trial.
This was at some point, I would say.
They knew he was being investigated, and they didn't tell the defense.
2023, yes.
Okay, and then I said you did not turn that over to the defense.
Right.
You started going to what Brady said, but you also had, didn't you, a statement by a fellow prosecutor who had been prosecuting for 20 years plus that said Brady did say he's leading testifying. And all these are in the area that's close to.
Thank you. Counsel, I don't want you to argue with the witness. You're giving a recitation of facts and demanding in some way she agrees with it. I don't mind you asking questions about it, but I don't want you to be arguing with it. All right?
I don't think he was arguing with her. He was just, being stern.
When you spoke to Detective Loretta, and we were talking about the conversation that you actually finally had with him prior to the first trial.
Yes.
Did you let him know that there were allegations made by Ms. Boutros and what they were?
Yes, because I asked him if there was any validity to it. I asked him if there was any validity.
Okay.
And that was his response.
And his response was what you just had told us about.
That is correct.
Okay.
So again, Ms. Boutros says you falsified this evidence. Did you? What's he going to go? Oh, yeah.
Did you speak to Ms. Boudreaux about it?
No,
No.
But based upon Detective Moretti's representation to you, you decided not to file Brady notice. Is that a fair statement?
no. Based on Detective Moretti's statement, Deputy Gorell's report that also denied any such thing as had.
Their reports don't jive though. Doesn't Detective Moretti say it was a joke and Deputy Gorell say it didn't occur?
Deputy Gorell says he was told he was not needed in his report. Detective Moretti doesn't mention anything about BSO assisting.
So.
Ooh, she's being cagey and evasive.
You decided not to say.
She's being cagey and evasive here, and I hate that. And Moretti is saying, "Oh, it was a joke," and the other officer, Gorell, he was saying, "I was just told I wasn't needed." And that's why the defense lawyer is saying, but those are different statements. So you took two different statements about what occurred, and you said, "Oh, okay, they denied doing anything horrifically illegal and possibly criminal." So you took their word for it and didn't think that we, the defense, needed to hear about this. That's messed up, people. It's astounding. And YNW Shakadzab. Okay, YNW Shakadzab, YNW church lady must miss trial.
Who was it?
YNW church lady, you say?
Who was it? Who could it possibly be? Was it? Oh, I don't know. Say it.
YNW church lady must miss trial. This, honest to God, I don't know if Melly did this or not. I can definitely see him being found guilty. And I was convinced early in the first trial that the prosecution had not met their burden of proof until, ironically enough, Officer Detective Melly, goddammit, and until Detective Moretti got on the stand. And when Moretti testified, I thought, okay, I think they've proven beyond a reasonable doubt, because there's questions that the defense didn't answer. So my flip-flopping on this case from thinking, I don't think it's been proven, to, okay, I think there's enough to convict him, was because of this officer now that has said he's going to falsify evidence. I don't think it rises to the level of something the judge is going to throw it out with prejudice and let Melly go free right now. I don't think it's risen to that level for a bunch of reasons. But if it did, I would certainly understand. And it would be on the prosecutors, not the because the people, oh yeah, the defense got him off on a technicality. Oh, he's rich, so he can afford these good lawyers that can find This is not a technicality. And you can't blame the defendant. You can't blame the judge. You can't blame the defense lawyers. You blame the prosecutors and the police for their shitty, illegal, improper, unethical, and bad detective and prosecutorial work. That's who you blame if Melly walks without a trial. Juror X says, did they put a gun in his hand? Did gunshot residue? Gunshot residue is a whole issue in Florida, but the short answer is no. But yeah, so this. Let's just continue. I could rant for hours about the bullshit that this is, and we've still got 2 hours to get through.
Send out a Brady notice disregarding what a fellow prosecutor said that she heard.
Yep, the fellow prosecutor said that she heard this. The two guys that were involved said didn't happen and it was a joke, and she didn't tell the defense. Why not?
Making decisions in her case. And that's clearly not allowed. It is a fact, though, that you did have a fellow prosecutor who did say this did occur, correct?
Right.
Yes, and said fellow prosecutor also did not request any police reports to be done or do any additional.
It's not her job to
documentation
request additional
if something
documentation.
had happened, to immediately follow up on such.
It's her to tell
events
you,
if
and
it
it's
had
your
occurred.
duty to turn the information over.
Did there come a time when you did issue the Brady notice?
The first Brady notice that was filed in this case, I believe, was in February of 2023 with regards to Miss King being under investigation.
Okay, and then let's get to the Brady notices that really deal with this issue here. There was one that you issued on the 23rd of September, correct?
I'd have to look at it to know exactly which one you're speaking about.
I'm going to show you what the put into evidence as defense exhibit 1.
Thank you, sir. Yes,
Okay, you recognize that?
I do.
What is it?
I
This
do.
is the Brady notice that I drafted that is an accurate statement of what happened.
Okay.
Oh, an accurate statement of what
Why
happened.
was this sent out in September of 2023?
Look, she's got this smirky thing going on. They've sent out this report, this Brady violation report, or this Brady report on what actually happened. Again, this happened 11, 12, 13 months ago. When did they issue this report? 3 weeks ago. After the trial was done, they released their report on this Brady issue. And look at the smirk on this Bish's face when he points out the fact, why did you wait until after the trial, months after, almost 3 months after the trial finished, to bother to mention this report?
Okay.
Look at this smirk.
Why was this sent out in September of 2023?
Mr. Judge,
Now he's going into for any work project and asking her why she did what she did related to the case.
thank you, sustained.
You sent this out in September of 2023. In fact, September 23rd of 2023, correct?
That's correct.
Okay. Was there more that you learned about this incident between the time you spoke to Detective Moretti and September 23rd?
Ooh, good question.
Could you clarify what you mean by that?
No, come on. See, she's fishing for an answer.
You know this report for strong.
Saying he knew about
Yes.
this before the trial. You just issued the report 3 weeks ago. Did you learn anything new in that period? She's going to say no, and he's going to say, well, if you learned nothing new, why didn't you tell us about it
And then
11 months ago?
September 23rd of 2023, you filed this Brady notice.
Yes.
So I'm asking you, what transpired between the time you talked to Moretti and the time you filed this Brady notice?
I reviewed the contents of the statement again on that. That was the most recent thing I did before filing that particular Brady notice.
So the contents of whose statement?
What?
Miss King's statement with regards to the witness tampering.
Okay, but there was nothing about the lying incident in there.
No, there was not.
So how did that change as far as your filing Brady in September, as opposed to what you knew back when you talked to Moretti, whether it was January, February, whatever, of 2023?
In terms of what I had learned from conversations with other people in the office, is that what you're asking?
I'm asking you, what changed that you talked to Moretti in, let's just say, the spring of 2023? You talked to him then, you learned his side of it, you checked on Gorell's report, and then no Brady is filed. And I'm asking you, what changed until September 23rd, 2023?
I was not a party to any of the meetings or anything.
Well,
that
that's
Ms.
not
Boutros
the answer
had,
to the
so I
question.
couldn't tell you on that.
Oh,
As
please.
far as you're concerned, what changed?
Exactly.
In terms of filing,
You don't give the Brady notice before the first trial. You give one now in September 23rd. What changed in that period of time?
On her legal thinking, and
But you can answer that.
Excuse me.
Yeah, she can answer that.
Hey, go ahead.
What changed?
In terms of there was additional discussions and conversations.
Don't
about
obfuscate,
the
bitch. Answer the
attorney's
question.
Okay. And who were these conversations with?
I'm going to object. It's going to proceed in office and have to interact with those prosecutors and speaking about their case, a case or any case. That's all privileged or private.
Thank you. Speaker.
Yes, Your Honor. First of all, the question was who she met with or who she talked with. I didn't even ask the substance of the conversation. Secondly, if I was to ask that, the bottom line of it is this is not work product that is not discoverable. This is work product that is discoverable. And if you'd like, I'll go into that argument right now.
Now, the prosecution is saying she doesn't have to give this information because it's part of her job to prepare for the trial. It's not a document that is discoverable. It's called the work product. It's the product of their work preparing for the trial, doing their stuff. He's saying there's an exception to this. Now he's going to argue to the judge why she should have to turn over work product.
Your Honor, first of all, I'll cite to the court the case of State versus Raven. It's 495 Southern 2nd, 257, 1986.
Sorry, one more time, 495 Southern 2nd.
495 Southern 2nd, 257, 1986. It's a third.
Yeah, Mr. Portley here, he's the angry one. He's the guy that was challenging the judge yesterday.
As far as the directness here, on fact versus
He's
opinion,
feisty.
Type of evidence and whatnot. So I'm not going to tell the court there is a stream of case law. I'm going to just explain what it is.
Do you have a copy of that case?
I'm sure we have others floating around here, so let me give you this.
And I got a copy for you. Thank you. You have that site, Counsel?
We have the case on.
He does look like Don Rickles from the back.
This has some highlights underneath it, underlying. Any objection to that?
No. And as you see on page 4 of what you were given, work product can be divided into two categories. Factual product, factual information which pertains to the client's case and is prepared or gathered in connection therewith. This is an investigation dealing with whether or not a witness lied and whether or not that witness is suitable to basically testify in court, and much to be done as far as Brady. This was not done in preparation of their case.
Right. I agree with him. But I'm not the judge, so. Liz Bots with the $10 super chat. Nothing to say, just love you. Love you too, Liz Bots. You are a fantastic supporter of the show. Deeply appreciate it. Thank you. Thank you so much.
I'm sorry, I should counsel.
Backward product is subject to upon the showing of need and undue hardship, while opinion work product is protected from disclosure. Again, this is not opinion. We're not asking for it. That's State versus Loman, 721 Southern 2nd, 1249.
Thank you. Yes, sir.
And then lastly, Your Honor, it's going to be Kidder versus State, 117 Southern 3rd, 1166, 2013. That's a second DCA case. Backward product traditionally protects that information which relates to the case and is gathered in anticipation of litigation. This evidence had nothing to do with the case in chief.
Absolutely.
This has to do with the credibility of a witness.
Correct.
They
I
didn't
agree.
prepare the credibility of a witness for their case in chief. This came upon their desk because the witness is a liar.
Thank you. Yes.
Thank you. I disagree. I believe when the case counsel originally cited to you, Your Honor, State versus Drayton, 195, 257, 7 is exactly what they're trying to do and what they're trying to ask the witness. I believe they're quoting from or looking at number 5 on page number 4 of that opinion, where they're talking about being divided into 2 categories. It says it is paring down the convention therewith and opinion or product, i.e., the attorney's mental impressions, conclusions, opinions, and theories concerning his client's case. And that's exactly what he's going into, is her mental conclusions for dealing with other attorneys and discussing the case, your opinions. That is exactly what you're saying you can't testify to. Also, the court inside the state attorney's motion to quash the subpoena and/or for protective orders on page 4, number 7. There's a quote, Ian versus Imano, June 9, 4, 7, 639, page 640. The prosecutor must necessarily perform investigatory functions incident to the primary to prosecute in all cases. It is unnecessarily burdensome to subject them summarily to discovery by oral evidence.
It's not unnecessarily burdensome to hand over the report.
As opposed to a prosecutorial capacity, subjecting prosecutors to this type of discovery of their investigation would require disclosure of the work product, seriously impede criminal prosecution.
Anything else? Anything else?
Yeah, but this was not an investigation. Ms. Bradley was not in charge of investigating this. This is information that came up during a statement given, and with that information, the state attorney's office, from top to bottom, looked into whether or not it was Brady material and whether it should be given. This is not preparation of your case. This is a function of the state attorney's office, making sure that they don't present urgent testimony. It's not for their case.
Hold on.
Excuse me?
Are you all done?
Yes.
Thank you. Objection notice sustained. Objection.
Oh, he sustained the objection. Ew, I don't like that. But don't drop your stuff, dude.
How many meetings?
Why's the fat guy always got to drop stuff? I don't like that. I'm not a judge. I don't know Florida law, but I found the defense lawyers here to be quite persuasive. Well, let's do a couple things here. Light Rain says legal vices. I'm sure you can maintain outrage for both the corrupt cop and the murderers. It's not an either or situation. Absolutely. You're absolutely correct. Where my outrage is when you intercourse with the system, when you fuck with the system, when you cut corners, when you're corrupt, when you somehow think you're above the law and you're trying to take away someone's liberty and freedom and occasionally take away their life. I'm all for what the evidence shows. If you're proven beyond a reasonable doubt and convicted, well, yeah, there you go. I can disagree with jury decisions, but we've gone off on quite a few guilty people here and quite a few murderers. Some of the streams we've done. Go back and look at some of them. The Texas Border Patrol agent guy that was offing hookers. Bad guy. Definitely needs to be raged about. The guy in Florida that chased his wife, that his wife went woo with some guy in a bar, so he went home, or his girlfriend, I guess, went home and slit her throat and left her to bleed out and stabbed her a bunch of times in the face. Yeah, bad guy. There's plenty of rage to go around. Just the rage has to be directed where it should be directed. And right now it's squarely at the detective in this case and the prosecutors. LC Merritt, if we had a drinking game for her head bobs, this stream would have been over 21 seconds, would have been only 21 seconds long. I can't falter. If you watch me for any length of time, you'll see I'm a bobblehead too. I tend to move a bit when I talk. And I mean, to the point where I annoy myself sometimes. Chaz Berglund, who's been a member for 7 months, says this pretrial is nuts. D's nuts. These pretrial nuts. You're right. Absolutely. This pretrial is nuts. I said it a lot this morning. I'm saying I've never seen anything like this. We'll call Magic with the $5 super chat because love you 5 less than Lizbot. All joking. Thanks for playing this tonight. You are very welcome. We'll call Magic, who has a magic cat. And we want to check him out. Go to Will Call Magic's channel and check out his magic cat. Right. We've also got a like and subscribe poll up here, by the way. Hit that like button. We've got 400 people here-ish and 200 likes according to mine. So that's like half of you haven't done your job. The other half, get down there and hit that like button. Hit the subscribe button. And make sure we get this out there to YouTube. We should have 200 more likes like that. Oh my God. What? YouTube has said to continue your session, complete a brief verification. This extra step helps us keep your account safe by making sure it's really you. I have to verify myself. What the hell do I have to do here? Okay, I have to sign into my Google account. Making sure it's you, please sign into google.com. This request comes from Chrome, but yes, okay. I did that. Your phone can't locate your device. Move your phone closer to the device where you're signing in. It's on top of it, for fuck's sakes. This has literally never happened before. More ways to verify. Use your nearby phone or tablet with Bluetooth. Tap yes on your phone or tablet. I can tap yes on my phone or tablet. Okay. This is the stupidest shit I've ever seen in my life. Hang on. Trying to change your YouTube set. No. YouTube is trying to do it. All right, there we go. I've tapped the number. I'm verifying it's me. This is insane. Why is this happening? There we go. Welcome back, people. Apparently, YouTube thinks I'm me. Congratulations. We can now continue. Brian Miller, member for 4 months, says if Melly goes free with shenanigans, will they take it out on Bort? Yeah, Bort's supposed to go to trial either at the very end of this year or the beginning of next year. I got thoughts about that too. Alan Wall said he had to do that earlier tonight. That's the government starting their shit. Yeah, well, they know where I am. I'm in Korea. Come and get me. As we were saying, we have the like and subscribe poll up there. 400 of you here. 227 of you have now hit the like button. We need to get up to 400 likes just like that. We can do it. Do that while I'm reading the poll. Subscribe to the channel. If you have already subscribed, please make sure you're still subscribed because YouTube fuckery, they just unilaterally unsubscribe people from channels because they want to. I'm sorry, you're doing too well and you've got too many subscribers. We're just going to have to take a bunch of them away. That's what they do because they're YouTube. And then take our like and subscribe poll. The question is today is, what do you think should happen with this case? A retrial, or let Melly go, leave Melly alone, or let Melly rot in jail and or take the needle. Where do you stand on this? And only 1% of you are saying that he should just be left to rot in jail. I mean, he has to go. They have to. I mean, it's kind of a fake poll. I mean, he has to have another trial. So there has to be those are your two options: retrial and leave him alone, or I hope he's found guilty is kind of the way that should have been worded. So 33% of you say leave him alone and let him go, drop the charges. 66% of you say retrial. All right, well, let's find out how this goes. Where are we at?
With administration meeting either Ms. Falk or Mr. Pryor.
20 Legal Vices memberships. Give Tankrat a super special thanks if you get one of them.
I was in trial continuously from about late August of 2023 with the Honorable Judge Fine.
The Honorable Judge Fine.
Last week, I finished a
Tankrat dropping
murder trials in
10 oil dollars. Lol, YouTube trolling you. Good morning, Vices in chat. Good morning, Tankrat.
That I was present at, I would say 2, perhaps 3. I couldn't tell you exactly.
And without going into the resolutions of it or anything like that, the subject was, though, whether this should be given out as Brady.
In term,
Sustained.
Okay, let me just address this real quick here too. Pinochet's helicopter tours, long time no see. Welcome. It is good to see you. Hey, Vice is on tonight. You usually have my morning earballs, and to think I was going to settle for Ancient Aliens until I saw that you are on. We are on this evening, your time, this morning, my time, because of what went down just about, 8, 9, 10 hours ago during this YNW MELLY pre-trial motion hearing. We covered it all morning long. This is insane. This is part 2, and we're going to continue going. Thank you so much for your support. Pinochet's helicopter tour is good to have.
Let's look at that first Brady notice.
that's okay.
Ooh, she's an arrogant,
Are you sure
snotty
that's
little
the
thing.
first one? I believe there was one that was
There was
filed
one before
prior.
that, the first one dealing with.
The complaint, yes.
Right.
U.S. drinkers need evening vices next Friday. Next Friday evening U.S. time will be Effet Friday, so there will be evening drinking.
Here it says, according to information from Ms. Mason, ASA Boutros, Deputy Gorel, nor any other BSO deputy was present in the conference room when this King's statement was taking place, when the search warrant was executed and the phone was seized by Detective Barrett.
Yes,
Did you find that to be true or not?
yes, that's a true statement.
Okay. The
Okay.
undersigned spoke with Detective Barretti in regards to this incident, and Detective Barretti said he asked Deputy Gorel if Deputy Gorel was there when the phone was seized. Deputy Gorel responded something to the effect, "I can be if you need me." If you needed me to be.
Yes,
Okay. Is that stated in Deputy Gorel's report?
Two things there. And this shows the bullshittery. The statement was Moretti is saying that he asked, or that he said testify that you were here when this went down, and Gorel said, "I was there if you needed me," or "I'll be there if you needed me." Something like past tense, needed. If you needed me to be somewhere where I wasn't, I'll say that I was. That's the first thing. It's not like I'll be there if you need me to, saying in the future tense, when you serve that, if you need me to be there, I will make sure I'm there. No, he said, I will be there if you needed me to be there. If I should have been there when you signed that or when you served that, then I was there. I will say I was there. That's the first bit of fuckery in that. The second is what he's getting to here right now. Gorel, when he wrote his report about what's happened, he never said that. He didn't say, well, I told him I would be there if he needed me to be there.
yes.
Okay. Is that stated in Deputy Gorel's report?
Deputy Gorel's report says something to the effect, I was told I was not needed and left.
Different.
So you do have a conflict then. Gorel's report said the only thing was he was told he was not needed, and here you have a statement by Moretti attributing it to Deputy Gorel.
Yes, there is a conflict.
Yes, there is.
Deputy Gorel.
Not until last week when he approached me in court.
Oh, Jesus. There's a conflict in the report and she didn't talk to him until last week?
Now, you sent this out on the 23rd.
Last week.
Yes, sir.
And that was after you had received this letter from Mr. Hazelstein. We shall use the mark as defense exhibit I.
Yes, this was received, I think, Friday evening. Yes.
Is that an accurate copy of what you received?
That is correct. That is an accurate email that I received.
I'd like to admit this as evidence.
Any objection? Any objection?
Now, you received this from Mr. Adelstein, and the next day is when you produced the Brady.
That is correct.
Is this a coincidence?
In
Or was
terms
there a
of,
response to this?
no, not at all. Actually, that letter was an incorrect. What Mr. Adelstein said in accusing me of having a
It's
copy of
possible.
the internal affairs
It's possible.
report was not true. I personally was not in possession of the internal affairs report. My understanding about a week or so later, maybe a little bit longer, was that Mr. Killeran had received the internal affairs report, but failed to disclose it or let me know that it had been turned
Wait,
over
so you
to
just-
the attorney's office.
You
The
just
only
admitted
thing
it was.
that I had at the time of the court date on the 22nd was the letter closing out the complaint as unfounded or unsubstantiated.
Okay, now, on the 26th, whereas the Brady
No.
put into evidence as defense exhibit 2, this was sent out by Mr. Killeran.
Yes,
Have you seen this?
I saw it after it was filed. I did not review it prior to it being filed.
Okay. This was your case, not Mr. Killeran's.
Correct.
Why would Mr. Killeran be sending this out?
You'd have to ask him. I couldn't tell you as to what he did or didn't do.
You did not authorize.
I did not.
Do you disagree with what's contained in it?
I do. I do not think it is an accurate statement of how I relayed the information.
So let me read the operable part, and you can tell us what you disagree.
Would you be so kind as to bring it up here? Because I do much better when I can read along.
It's like using the little goose.
Thank you.
Grab it there.
Ooh, she's so slimy and condescending.
I'll tell you what. Why don't you read?
Yeah,
Okay.
if you can.
Read that line.
Sure. As to the first paragraph,
I was going to say, just go. Let's go down to where you start talking about this.
correct. The first sentence indicates that the lead ASA assigned to this matter related to SAO administrators, that she spoke with Detective Moretti.
Well, please.
Sorry.
I thought that's
That she spoke with Detective Moretti in regards to this incident, and that Detective Moretti explained that his statement to Deputy Gorell was a joke.
okay.
Uh-huh.
So, is that true that Detective already said to you that what he said was a joke?
No, what was intended to be conveyed was that Deputy Gorell, his response was flippant in nature. That was the joking aspect of it.
What the?
Okay, so if somebody from your office sends out a Brady notice in this case, not authorized by you, correct?
That is correct.
And in that Brady notice that I just showed you, you're saying that there are incorrect statements of fact.
That is correct.
And the incorrect statement is that you were not told by Moretti that he was joking.
That is correct. The indication,
They've been saying that Moretti said he was joking since the morning. And since before of this, now she's saying he didn't say he was joking. He was saying that the response from the guy who said that he wasn't needed was a flippant response. Did he respond or did he say he wasn't needed? This is getting worse. She's not clarifying anything. I think she's making it worse. Enchiladas Unbreaded with the $20 super chat. Thank you so much. The smiley face. Thank you, thank you, thank you. Thank you very much. No comment necessary other than thank you. LC Merritt. At a minimum, this taints the jury pool over police misconduct, similar to OJ. Yeah, that's why, I mean, they've made a motion for a mistrial. If this, for this thing just to be, I'm not a motion for a mistrial, a motion for the charges to be dismissed. They've made that motion. If they don't get that, then they've made this motion that they're arguing now to recuse the entire prosecutor's office. And then, assuming this goes to trial, jury selection will start on Monday. And they're estimating that because of shit like this, jury selection is going to take probably until the end of November. So they're expecting about 2 months of jury selection so that they can get an impartial jury. But let's continue to listen to this absurd answer about whether the other guy said he was joking, whether he even made any acknowledgement it was a joke, or whether he gave a flippant response, whether she heard any. This is stupid. Now I was flabbergasted, I was bewildered, I was shocked. Now I'm just getting annoyed and pissed, especially with those little flippant remarks. And they're like, "Are you done talking yet?" Smirky things. I'm starting to get annoyed.
Has always been, and if it was inartfully conveyed at some point, the indication has always been that Deputy Gorell responded in a very flippant manner when asked about showing up.
What was his flippant answer? What was his flippant?
To Detective Moretti.
What was his flippant manner? What did he say?
I don't believe so.
Nope.
So
he doesn't mention that.
The flippant manner came from Moretti, and somehow you communicated that Moretti said it was a joke. Is that what we're putting together?
I did not say that Moretti said that he had made a joke in any way, shape, or form.
What the fuck are you saying, woman? What are you saying?
Made a statement that Moretti said he was joking.
My statement was at all times, and if it was ever not clear or misinterpreted by whoever was listening to it, was that Deputy Gorell made the statement that was of a flippant nature.
What was the statement? What was this statement?
So again, my statement that you never said that Moretti said it was a joke. That is a true statement. You've never said that.
You can answer the question.
That is correct.
Hey, LC viewers.
Then on the 28th, you filed
Big
another
thumbs
brief
for Lincoln Kane.
notice, and that's that's defense exhibit. Oh, I can't read it.
This is state's evidence number illegible.
Let me show you defense 3.
Sure.
And why don't you read again that last operable paragraph?
The undersigned inaccurately relayed to SAO administrators that she spoke with Detective Moretti regarding this incident, and that Detective Moretti explained that his statement to Deputy Gorell was a joke, when she intended to relay that which is contained in the Brady notice filed on September 23rd, 2023. Wow. Additionally, the undersigned relayed to a SAO administrator that the deputy was the one trying to be funny.
Mm-hmm.
How did you know the deputy was trying to be funny?
That is the same statement that is
That's not the
contained
question.
on the September 23rd notice.
But I'm just asking you that statement that the deputy was trying to be funny. Whom did you get that information from?
The deputy.
That is how Detective Moretti relayed.
Oh, Jesus Christ. Detective Moretti, a prosecutor, ratted him out and said he asked another person, he asked another police officer to falsify a statement and say that this other officer was present at the serving of the search warrant when the officer was not present, and also reported that the other officer responded, "Well, I will be there if you needed me to be there," something along those lines. And then she said, "Oh, but I talked to Moretti and he said it was a joke." And then she reports that the other officer, Gorell, thought it was a joke. How does she know that she didn't ask Officer Gorell. She didn't ask Officer Gorell if he thought it was a joke. She asked Moretti. Moretti does it. Moretti says, "Oh, I was joking." And Moretti said, "Oh, and the other dude knew it was a joke because he responded in a flippant manner." So she asked Moretti if Moretti falsified evidence, and he said no, it was a joke. And then he also said, "Oh, and by the way, you don't need to ask the other officer if he thought it was a joke, because it was he made a flippant response, which indicated to me, the guy that's being accused of wrongdoing, that he knew it was a joke. I meant it as a joke, and he responded flippantly, so he knew it was a joke. You don't have to talk to him." That is some bullshit right there. That is some bullshit.
The conversation to me.
That's how Moretti relayed the conversation to me.
Whom did you get that information from?
That is how Detective Moretti relayed the conversation to me.
Okay.
That it was a flippant, off-the-cuff remark that was not intended to be
Off the cuff
any sort of, and not taken as serious by Detective Moretti. Detective Moretti didn't use any sort of information or did not try and say that Deputy Burrell was present or assisted in the search warrant in any way, shape, or form.
What exactly did Moretti say that Burrell said?
Yes. What was the flippant comment?
Something to the effect of, I can be there if you needed me to.
That's what the fuck they've been saying.
Is that a response to something Moretti said?
My understanding is from Deputy Burrell said that Detective Moretti asked for his name and CCN and if he had been outside when all of this happened. And so also, if you will, remember, Mr. Aronson, this time, when all of this happened, it was brought to my attention initially when I was speaking to Detective Moretti that there was an allegation of a battery by Miss King.
What I'm getting to right now is, if I have it correct, Moretti says that Burrell made that statement. And I was asking, what would Moretti have said, or did he tell you anything that prompted Burrell to say, I could be here if you want me to. I could say I was here if you wanted to, whatever the exact words are. What did Moretti tell you said that prompted that?
Detective Moretti, I don't have an exact recollection of anything that he asked or said on that, because my question to him was, what did you say? Did you ask Deputy Burrell or any DSO deputy to say they were there during the warrant?
And then he responded to you, no, Deputy Burrell said to me, I can be here if you want.
Yes.
Unprompted by this.
Deputy Burrell's version was that Detective Moretti asked, were you the one that was outside or something to that effect? I was not present. Can't tell you exactly what happened.
Well, Moretti denies that, doesn't he?
I haven't talked to him about it since then.
So you're not sure whether Moretti disagrees with Burrell. You know that Burrell doesn't agree with the fact that he doesn't put in anything about this, and has never said that in fact he made these statements. And then you have a prosecutor who says it did happen. So that's the information you had in front of you, correct?
Leading in compound.
I don't like arguing, counsel, respectfully, but I think these things are already established.
Now, let me ask you some other questions.
Sure.
Sure.
At the trial. Well, first of all, as far as Detective Moretti goes, he is the applicant on almost every search warrant in this case.
Quite a number of them, yes.
Oof.
His credibility.
Oh my God. Yeah. Again, talking about Officer Moretti, apparently he was the officer that gave the sworn statements for most of the search warrants that were issued. And oh my God. And at issue here is the fact that he is falsifying search warrant affidavits. And he's been responsible for giving the affidavits for most of the search warrants in this case. Doesn't look good.
It's an issue.
Of course.
Doesn't look
Quite
good.
a number of them, yes.
His credibility is an issue.
Of course.
Because he's the applicant. Okay. And you never let the defense know about this possible credibility issue before any of those motions would have been argued.
Relevant, also now going into, again, her opinion on what she didn't take.
Hasn't it already been established? I'm asking, hasn't it already been established?
Probably right. What did we know that Detective Moretti had a lot to do with the search warrant? He's on the affidavit, correct?
Yes, almost
He executed it, correct?
a lot of them.
At most of them, he received the evidence from whether it was Facebook or whatever social media, he received that evidence.
Correct.
He was the one that had to ferret out what was relevant, correct?
In terms of that would have been something that I would have done as well as the prosecutor on the case.
Okay. What else did he testify to or what other subjects?
In terms of other subjects, he testified to being present at the collection of evidence, receiving information from the medical examiner's office. Testified for about 3 days, so I couldn't go into every single area off the top of my head.
Okay, but his credibility as to all the things
Dude's looking
he testified
angry.
to certainly would be an issue, correct?
And it was attacked vigorously by prior counsel.
Tell her she's a bitch and to shut up.
There was a motion to suppress the Judge Siegel, correct?
A couple of them, I believe, about 3.
And I'm here. I just have to turn the camera off for a second.
I'm understanding correctly what I've been told, and that the only evidence in that motion to suppress was what Detective Moretti testified to.
You'd have to be a little bit more clear as to which motion to suppress or which specific issue you're talking about.
Fair enough. But did some situation like that occur where there was only his testimony, there was no other documents or anything?
No, not to my recollection.
Were you ever told that if you filed the September 28th Brady notice that your license to practice would be revoked?
No.
Oh.
Were you ever instructed to file a Brady notice?
Yes,
Did you comply with it?
I did.
That is not why Mr. Killerin ended up sending out one that you did not comply?
I don't know why Mr. Killerin sent out what he did. I couldn't tell you. He did not consult with me.
Jonathan, we have 2 minutes.
Yes.
All right. Hang on.
All right, they need a couple of minutes so we can mute there and take care of some super chats and then fast forward. All right. I said I'm here. I just had to not wipe faster. I said I'm here. I just had to turn the camera off while I worked on some things. I'm trying to get a camera thing worked out here behind the scenes. Vernon Passero, the $10 super chat. Thank you so much. Just like the criminals she prosecutes, she blames others and takes no responsibility. She is obfuscating. She is, just answer the questions. Suck it up and take it because you deserved it. And Blue Varo has been a member for 6 months. Thank you so much for being a member of the Clean and Sober crew for 6 months.
I'm sorry, I thought you had asked me if I wanted to ask the question.
Right, well, counsel asked for a 2-minute break and we wanted to speak with his colleagues, and I gave him that, so if you're ready, you may continue, but we're all ready to proceed. Go ahead.
See how we're doing on breaks here.
Just a couple of questions. I think you answered it.
Okay, there's a
but other people don't think you did.
good sized break coming up
You
here.
did meet with
All right,
Mr. Pryor
in a
on this
while.
talk, several times about the Brady issue.
At least 2 that I
And I
recall.
think you said 2 to correct that.
Yes.
My recollection. And did you go over the specific notices? Not asking whether they changed it or anything. Did you go over the notices?
I'm sorry, I'm gonna read that again. Even trying to put it that way, it's going into the inner workings of the office and what she did with her superiors and the decision making process.
Thank you. Sustain.
Was the subject of Brady notices?
At times.
She can't sit still.
Without going into what Moretti said, did you explain to Mr. Pryor his thought and Mr. Killerin what was said by Detective Moretti? Like I said, I don't want you to go into what it was. Did you just explain it?
just as I stated on the September 23rd Brady list. That was how it was explained.
Thank you. Hold on, Councilman. Do you have any questions? No. Thank you. May step down. I'll call your next witness.
All the same people that don't have here.
Well, there we go.
So we'll make
That's
sure- Yes, sir.
That's not supposed to happen.
I just wanted to explain some case law.
What was that?
Maybe, Your Honor,
I'm still here.
what work product is and what fact work product is. And the threshold that we must argue to have Your Honor persuade
The
you
wall.
that information.
Hang on, everybody. This is fun.
should come in.
There we go.
And we
Hi.
just haven't gotten there. I know that Your Honor made a ruling, but I'd like to have Your Honor maybe. this is
Stop
where we
touching
are.
things, Vices.
Go ahead. Go ahead.
So
Or am I supposed to be here? Am I?
You're not called anymore. You're the lead counsel in the case. I'd rather have you here.
So both sides talked about the Sam Brady case from the Third District Court of Appeals. And the side on it, Your Honor, is 495 Southern Second, 250.
No, that's the blue curtain next to me. People saying things. No, that was the blue curtain that's sitting next to me here.
The questions that we're asking and the information we're seeking isn't about other people's opinions about what maybe the law is. What we're seeking is, and why we've alleged what we have alleged against the elected state attorney and the others listed, is that they had knowledge about what had occurred in October of 22, where the allegation and the sworn testimony against Moretti
Yes.
trying to solicit perjury happened. And what they did between that day, October of 22, and where we sit today, where these flurry of Brady notices occurred that are in conflict. So those are the differences of that about what they did. Was there an investigation? Did they consult anybody? Did they tell Ms. Bradley to file something that she refused to file? Did they realize?
Well,
that
these are
the
two new lawyers.
first degree murder case occurred in its entirety before the information about the lead detective trying to suborn perjury was known to the defense before that entire trial happened?
It's the
And
curtains.
we've asked.
See, I can prove it. It's the
Because
curtains.
we wanted to show that all
Curtains.
had occurred. that
Dog.
nothing was investigated. that
Curtains.
Sat on it for that whole time.
Dog.
And the knowledge of it and
Not
what,
ass.
if anything
Curtains.
wasn't done, went all the way up to Mr. Frost. So they moved to quash it based upon the 5 days, which in this statute itself says that time limit can be altered for good cause. And the case law is clear that the subject matter of it, it's only protected under work product, under the statute they cited, if it's opinion work product, not fact. The facts we want to allege is who knew what when, whether anything was done about it, not the reasons why, not the opinions of law, but the facts of who knew what when, and what happened that we're sitting here a couple days before trial without the benefit of knowing all that and whose fault it was that we're sitting here 2 days before trial.
You know my
years after
microphone
this
is louder than
happened,
the court, so I can talk
without
over them.
knowledge. So the case law says that fact work product is admissible and subject to discovery upon the showing of need. And whereas opinion testimony is absolutely or nearly impossible to be, and is privileged. So this is a black letter law from the 3rd DCA under the Drayton case. This is fact evidence that we're asking for. When the state jumps up and says it's opinion, that's not what we're asking we're asking for who knew what, when, and how, why an investigation was never done of Moretti. If a seasoned prosecutor with 20 years' experience testifies that she heard this man say it, and then the case is just given back to the particular prosecutor on this first-degree murder case seeking death penalty against Mr. Devins.
Right, that's what I'm saying. I
And
love
she
this
said,
guy's
"Well,
passion.
I looked at the statement, and I didn't know about this, and I didn't do anything about it." We want to show that nobody did anything about it, and that if she compartmentalizes it into saying, "Oh, I only knew this little bit, so it wasn't my responsibility," and ASA Rucho said on the very day or 2 days later, we had meetings about this with Mr. Pryor, with Ms. Fall, with Mr. Keller, who was notified the same day. Why wasn't there any investigation? And I submit to you, the reason is because they didn't want to upset a first-degree murder case that went on in its entirety without this ever coming up. Without, they just did an emergency investigation on allegations of Mr. Devins and him doing something improper with witnesses, witness tampering. Well, they sat for a year and never even bothered to see whether or not one of their own prosecutors' sworn testimony that a lead detective tried to suborn perjury was thrown under the rug and never investigated. So we want to know that. And the way the state is trying to argue why we shouldn't have that is technical procedural stuff under the rule, which is, oh, you need 5 days. Oh, this is work product. It's not work product. And the 5 days can be waived. And we're 3 days before a jury trial where Mr. Devins has a right to the speedy trial after the mistrial. He never demanded speedy trial. It's a law. There has to be a speedy trial after a mistrial. And all this stuff was brought to our attention less than 10 days ago and up to today. And we're just learning, and you're hearing testimony on the right now, the eve of trial as to some of this, and we're getting blocked from the rest of it. And I would ask Your Honor to look at the rules and show that justice requires, and there is good cause to have, Mr. Pryor and Mr. Keller and Ms. Falk come in here and say, what did she say today? Did she say that Moretti said this all, but it was a joke, which is what Ms. Lutro said she said to others, that the others are the ones that are witnesses to get that evidence.
I didn't say
got
anything.
that evidence, and we're completely forgetting it
Did I?
because of procedural time restraints on subpoenas when we don't have the time, and we learned of this in an emergency nature without the ability to subpoena.
I don't think I said anything.
Within the 5 days.
Whatever.
So that's where we are right now. Your Honor, in order to be able to make a determination of whether both Ms. Ms. Bradley and the rest of the state attorneys should be disqualified or recused is partly based on what Mr. Pryor, Mr. Killen, and Ms. Falk has to say, so we know whether or not they didn't do anything about this, how that could occur for 11 months in a first-degree murder case where there's such an allegation against the lead detective, when they're standing behind mere days of procedure and the wrong interpretation of work product. So I'd ask Your Honor to look at this again, and in order to ferret out justice, and not in the name of having the state ram a first-degree murder charge.
Okay, we can legitimately have a drinking game with every time the defense says ferret it out. That's kind of a thing now, I think.
The main witness in the case, it's not fit. And so I'm asking you to relook at this.
State which be heard.
Yes, sir. Going back, briefing, then discuss consulting and applying. That is a part of opinion work product. And it's very difficult to separate out. We must say, well, the fact is what did she tell us? They're in there, they're talking, and they're looking over the entire thing, going over their mental impressions of what happened, trying to make decisions. All of this then filters back to Brady, and whether or not he is easy. But we're not there yet. I just want to sound about things. The problem is, and I know I sound repetitious, when this court looks at the motion that they have made to keep my office, as it stands right now, this court will have no choice.
He's unhappy with the prosecution and Detective Moretti, I believe.
And we're sitting here today arguing all of this on a motion that is completely and utterly legally insufficient. So I don't see any benefit in going further into the office's, what inner workings of the office and opinion and what work by any of the privileges, when they don't even stand on a proper motion. They're standing, well, then they function for this statement, you sell, must, so.
Thank you. Anything else, Counsel? Thank you. You have any other witnesses?
Only the ones we can't call.
Talking about Mr. Pryor and Ms. Falk and Mr. Kilroy. Thank you. Counsel, so you know, nobody asked me to set this case down for hearing today. I know the trial's coming up. It's supposed to go on Monday. I set it down for hearing because I was concerned about it because I thought this was something that was very important, needed to get resolved. So I set it down for hearing. Nobody said, you know, time isn't good, i.e. we need more time to do X, Y, or Z or get subpoenas out, anything like that. I specifically asked Bradley to be here because she's the lead attorney. I look to her as to these Brady notices because it's her obligation to disclose these things. I specifically wanted to hear from her. She's the lead attorney, so I had her here. But in any event, regarding the state's objection to the things regarding Mr. Pryor, that objection is sustained, and to Mr. Killoran and to Ms. Paul. So I don't know where we're at now. There's no other witnesses for the purpose of this hearing. If you want to, I understand your argument. If you have something you want to argue in addition to what you,
I gotta stop this. I'm sorry. This is someone who doesn't know how things. Della Sander saying, hope Jeffrey likes his contributions. Just gave $5 out. BCLM tired. I don't know what that means. Because I'm tired, I guess. Jeff needs to recognize all dollar donators. Not doing that again. Try to cancel my $5. Bye. Della, you gave it 9 minutes ago. Oh, I'm sorry. Now it's 11 minutes ago. Super chats, we talk when there's a break in the trial so that I can address them in a manner that they deserve to be addressed. We don't talk, or we super chats are made for the breaks so that I can talk about them and address what you're raising. We talk over the chat with the regular chat. You got to give it some time there, Della. If you want to cancel your $5, cancel your $5. I don't care. But as you were saying, apparently you've changed your mind. Appreciate your commentary as always. Everything you're saying. Me, love you, Jeff. You're my favorite LawTube personality. You beat them all so smart. Apparently not anymore. I was getting ready to read that as soon as the judge stopped talking. But it's been 11 minutes. When we're in trial, sometimes it can be an hour before people's super chats get read. Chill with the super chats. Jesus. So now we had to stop the trial to talk about the $5 super chat, which to me, $500, $2, it doesn't matter. I read each and every super chat that comes in because it's people parting with their hard-earned money to support the channel. I do that. I read them all. You just got to give a little more time. Jeez. Well, but before Adara the Wholesome starts going off the rails because it's been 6 minutes. Just kidding, Adara. I know you're cool. Late night law racks. It must be my birthday. I'll have some honey jack and have a drink dedicated to you, Mr. Rax. I'll listen during my beer run. Thanks. Thank you so much for the $5 super chat. Thank you, Adara. You rock. But Della, come on. You got to be better than that. Do what you got to do. But God, 11 minutes. Well, it was 9 minutes when that came in. So, you know, it was whatever. Chill the fuck out. Jesus. I love each and every one of you. And nobody gets shortchanged because you are literally throwing your hard-earned money at me for this. So, yeah. All right, let's continue now that the Della drama is over. Jesus. Let's go. Sorry about that. Sorry about that interruption about super chat. We had to interrupt to read super chats about super chats. Tank Rat. I never see. That's the only thing that I still mention you every time we come up. The only thing that doesn't show up on my screen and get flagged are the memberships. And Tank Rat gifts the shit out of memberships, and that's why the mods always let me know when they're gifted, because I can't see them unless I'm specifically looking at the screen when they come up. So yeah. Torin 3, don't read this until next stream. Oh no, buddy, we're reading it this stream. We're reading this stream. Well, you kind of did jump my shit and said you're trying to cancel your shit and back out because you didn't get your super chat read in 9 minutes. So, Anywho, enough drama. Not that was really drama. Anyway, just give some time for the super chats, peeps. Let's go. Thank you, Torin 3. You're awesome.
About, disqualifying Ms. Bradley and or the Office of the State Attorney. I'd like to hear it. So if there's anything else you want to say or share with me about the motion, I'd like to hear it.
Well, first of all, Your Honor,
let's focus back on the
motion to quash, and they asked for a hearing as soon as possible. We assumed that we were going to be in front of you yesterday, and if that had occurred because they asked for an immediate hearing on it, we would have then been able to say to you, Your Honor, this is the situation we're in. Can you help us out and allow us to give a subpoena within a day? But that did not occur.
It did not occur, and that is my fault, my office's fault. Evidently, it was
now. People, be nice.
My secretary, Ms. Ingrid.
Be nice to Della.
And, she showed me a response. Did not see that in the email. Didn't show me the email, but didn't bring it to my attention that there was a request there for hearing. I didn't realize that or didn't see it. Wasn't advised that. My understanding was there was no phone call regarding hearing. But regardless, there is something in the note, and I saw that this morning, or excuse me, yesterday, before I left, and I told Ingrid to put it on in the morning. So that's how that happened. That was my office, my fault, nobody else's fault. They did request a hearing. It was in an email. I assume you got it, but I didn't see it.
So, Your Honor, with that in mind, our position has to be that we filed the motion, you set the hearing. The amount of time that you gave us for the hearing, as far as when it was set, was within that 5-day period that the rules require us to give notice. Therefore, technically, we could never comply with that rule and be able to get notice. Also, at that same time, contemporaneously, we received notice from the state as to depositions that they will not confer with us as far as depositions, and that we have to subpoena them for everything. So there was a breakdown in us basically being able to call up the state and say, hey, can we get this done? Can we do that too? The communications haven't been the greatest. But the bottom line of it is that we expected to be in court on Thursday. And at that time, we would say, Your Honor, we need your help. But we didn't have a hearing yesterday on it. But regardless of it, we still need the court's help. And what the court seems to be saying is, well, I'm not going to help you, and you can't call these witnesses, so go ahead and argue. We didn't do anything to put us in this position, Your Honor. The court set the hearing within 2 days. The rules say that we have to subpoenas that get 5 days notice. The state wouldn't take our subpoenas because of that. We come to court, and the people we want to have testify are in this building, and the court is not exercising its power, which the court does have it, because they are the state, and the state is a party to this. So you have the power to have them come down here, anybody in the state attorney's office. You won't exercise that, and then you're telling me to argue right now. This violates due process, Your Honor. I mean, what due process have we been given? No access to the witnesses, can't subpoena them, no time to get access to the witnesses, a 2-day notice. We've done everything that we could. You said we had a motion cutoff date, that got extended to tomorrow. We filed everything we could as quickly as possible to give the court as much.
Judges got to listen to this.
But for us not to be able to have these witnesses to show the institutional breakdown because of this Brady violation, this prejudices us because the state attorney's office, and there's a case here, is Cuerdo, and I'll get the site in a second for you. In that case, they go into the fact that a prosecutor had been disciplined by the state for other actions, but they kept him on, and they kept him on, and then in this case, they go through a laundry list of all the things that he did wrong in the case, and they hold it to the state attorney's
No,
office.
I'll read it
and
in a
they say
minute.
that under these facts of the case, the state attorney's office itself could have been the one that could have been recused for it, because it was institutional. Well, we only can get to institutional if we can talk to the institutionalists, and that's Ms. Pryor, that's Mr. Pryor, that's Ms. Falk, and Mr. Tillery. And you can only make your decision after.
See, now to summarize here, because I know some of you were distracted by chat, he's saying that they want to call other witnesses from the prosecutor's office, the higher ups that got these reports from the two prosecutors that have been on the stand. The judge is saying he called this hearing. He scheduled it 2 days ago. And the defense lawyer is saying, look, we don't have enough time to issue subpoenas. It's only been 2 days. We're supposed to have 5 days notice so we can get subpoenas put out. They can get subpoenaed properly and called into court. We've only had 2 days. So we haven't had time to get them subpoenaed to get here, but they're actually in this building. They're working in this building. Why don't you exercise your judicial powers and tell them to get their asses down here right now? They're free. And then you expect us to be prepared to argue this when we haven't had time. We need more time to do this. The judge has got to listen to this. I mean,
You hear that. And we need your help, because if not, our due process rights are being violated, that we can't call the witnesses. Our Sixth Amendment rights are being of confrontation.
14.
Our rights are being violated right now unless we get help from this court. Because we didn't set the times, we didn't set the parameters. We're just here doing what the court asked.
Anything else?
No.
Thank you. Anything else from the defense or state?
Again, yeah, the state, very right, and we did ask for an order to cross and move protected. Exercising our right to do that, and we did as well as witnesses that they tried to speak. And it still stands, the same reason this morning stands that. Counsel continues, again, I know that's not a broken record, he's talking about institutional problems, he's citing.
as soon as we wrap this up in about an hour, I'll be joining Nick as well. So we'll see y'all over there.
He's gone way outside the court order, and that results in prejudice. You don't have trial by him, and I have, again, he hasn't set forth any reason, he hasn't shown.
Danny!
He had audience conflict, and he says that there's from the state.
Oh God, someone catch her up in chat. This is impossible to summarize.
Have actual prejudice in order to solve it. So I just asked the court to kind of read over my response to Bob this morning, and at this point, I don't think there's any legal sufficiency to the motion that they're standing on at the moment.
Let me ask you this, the assistant state attorney, Ms. Bradley, the defense calls her as a witness during trial to rebut or to challenge the credibility of Detective Brady's test his credibility based upon this alleged allegation that happened in front of Ms. Boutros. They call Ms. Boutros, and they weren't called Ms. Bradley. Talk about corruption, bias, motivation to testify, things of that nature. Why wouldn't that be allowed? Why wouldn't they be able to cross-examine or put Mr. Moretti's, Secretary Moretti's credibility in question by something that happened previously? I.e. on this November or October 2022 meeting, the allegation where it said that by Ms. Boutros that the witness basically was telling him, "I'll do it if you need to. I'll be there if you need me."
Okay. I mean, trying to catch Danny on direct up here. I see that other people have joined late as well and don't know what's going on. I'm going to have to try to summarize this as best I can. This has been, what are you up to? Like 5 hours of absolute wild nonsense. This is a pre-trial motion hearing on a motion to recuse the entire prosecutor's office from the case. The defense is seeking to boot the entire Broward County prosecutor's office from handling this case. Why? Very, very quickly, as quickly as we can. This all centers around at least one affidavit for executing a search warrant against YNW Melly's mother, her cell phone. They wanted to get her cell phone and eventually ended up in sort of a physical struggle. But this all centers around this affidavit dealing with the search warrant. The search warrant was issued apparently illegally by the lead detective on this case, Detective Moretti. He told this other officer, Gorell, he said, anyway, a prosecutor heard the lead detective tell this other officer that basically if he's asked, were you in this room when the search warrant was served, say yes. You tell them you were in the room when it was served. And the officer replied, I will be where you needed me. I'll be there if you needed me, is what he said. The prosecutor overheard this. A prosecutor overheard this. So the prosecutor tells her boss and the lead attorney on this, it's the lead attorney that was on the stand just a minute ago. This prosecutor that overheard this, she was in the room when this took place. She tells her boss, and it goes all the way up to the highest levels of the Broward County State's Attorney's Office, that the lead detective on this case has solicited another officer to assist him in falsifying an affidavit for a search warrant against someone accused of capital murder. She says in a letter to her superiors, I will never work with this detective ever again because he's said that he's falsifying evidence. Now the defense, now this happened months before the first trial. The prosecution sat on this information. The lead detective is the subject of an internal affairs investigation dealing with this allegation of falsifying evidence. He is also the officer that signed most of the affidavits for all of the search warrants that were issued in this case. Well, ironically, she's spent 20 years with the prosecutor's office in her job as sort of the prosecutor who investigates and prosecutes prosecutorial misconduct. So she was exactly the wrong person to have in the room if you're going to pull these kind of shenanigans. So what happened is they had this information that this guy may have falsified evidence in the trial. He's the subject of an internal affairs investigation, and the prosecution did not mention that fact to the defense lawyers. So they're arguing a Brady violation because the state failed to turn over information that could be advantageous to their defendant as well as to discredit their witnesses. So they filed this motion to recuse because they're saying the prosecutor that overheard it, she's obvious. They said if they call Moretti as a witness, the lead detective as a witness, they are definitely calling I forgot what her name was. The other prosecutor that overheard this. It starts with the B, Bautista, something that for some reason, her name has just slipped my mind. But anyway, I'd say if you call the lead detective, we are calling her because she overheard this entire conversation. The lead prosecutor lady, she knew about this, so she's on the witness list. And then 3 or 4 other people up the chain of command knew about this, so they are going to be called as witnesses as well to get to the bottom of this. So they've asked for a mistrial based on the fruits of the poisonous tree from this search warrant. They're asking if that goes through, they're asking for the entire prosecution's office to be done. But so this guy is still under investigation, and they found out about this. The prosecution found out about all of this internal affairs stuff, all of this misconduct about 3 weeks ago. And so the judge is pissed. The judge is pissed because in the morning, the lead prosecutor wasn't there when she's actually one of the subjects of this entire motion. The judge basically said, I'm taking a break. You get her on the phone and you get her ass in this court because I want to talk to her. And that's where we are. Now they've had the arguments. Now they're arguing whether or not things should proceed. And the judge, he scheduled this hearing after 2 days, gave them 2 days notice for this hearing. And the defense is saying, hey, we don't have time to subpoena everybody. We've only had 2 days. The subpoenas haven't been issued yet. The people that are the subject of the subpoenas are the prosecutors. They're somewhere in this building. Exercise your judicial powers and get their asses in these seats so that we can have our due process requirements met. That's the best I can do in a nutshell. This is the wildest. This is a wildest. It's not a mistrial yet. It hasn't started. They've made a motion to dismiss and this motion to recuse the prosecutor. Jury selection doesn't start until Monday, if this goes as far as Monday. So yeah, there's not a mistrial yet. So they're just asking for the charges to be dismissed or the prosecutors to be recused. So yeah, this is an absolute, I've never seen, this is huge. This is an absolute nightmare for the prosecution because as I've been saying, how do you not put Detective Moretti on the stand? He was the lead investigator. He signed most of the affidavits for the search warrants that were used in this. And again, you put him on the stand the first time. The first question you ask is, have you ever falsified evidence? Have you ever solicited someone to falsify evidence? The second question you ask is, isn't it true that the prosecutor's office, the very people that are sitting here at this table, at least one of them has sworn under oath in court that they will never work with you again on another case because you have shown your willingness to falsify evidence. This case is going to be screwed. So there we go. Let's move on here to see how this goes over there.
Something to that effect. Whatever the language is, goes directly to his credibility. Whether it's true or not, I don't know. But why couldn't they bring that up to attack his credibility?
At that point, first of all, as I told before earlier, when if the trial doesn't fall the state is not objecting to any of that. We agree to it, right?
Well, how is she ever going to be able to try the case if she is a witness in the case?
Well,
right. You cannot try the case if you're a witness in the case.
You obviously can cross in or try. This is all theoretical.
It is theoretical, but that's what I'm concerned with is what happens if you have a situation where Detective Moretti's credibility is attacked by this incident that Ms. Boutros testified about today, and she is called as a witness.
Yeah, spoiler, it ain't a theory that the lead detective's credibility is going to be questioned. They've already unequivocally said if he's on the stand, they're calling the entire prosecutor's office as witnesses. And yeah, what Danny's talking about here is LC was saying the guy that is sitting down here in the bottom right corner, this defense lawyer over here in the bottom corner under the monitor, he's a bulldog of a guy. He got on the judge's case earlier. This is the afternoon session. In the morning session, because the judge was sitting here listening, and he just flat out called the judge. I said, look, judge, I can tell by the way you're sitting there with your arms crossed and you're smirking on your face that you think we, the defense, have done something wrong in this case. And the judge says, no, I am taking this incredibly seriously. I'm taking this very seriously. And then the judge proceeded to yell at the prosecutors for putting him in this situation. This is an off the hook hearing.
My understanding from, you may not have seen it, and I thought we talked about it this morning, but my understanding is, and one of the things that concerned me was defense counsel put down Ms. Bradley as a defense witness for this issue.
Ms. Bradley is the lead prosecutor in the first trial.
Her to call, and there's issues about it because you have two different Brady notices that Ms. Bradley signed, all right, that there's some inherent conflict in that. Why wouldn't they be able to discuss that in front of the jury with Detective Moretti? Yep. And if that's the case, and they're telling you that they're going to call her as a witness to do exactly that, why should she be on the case?
And at this point, well, you don't even know. You have no testimony from the detective.
I agree with that. I totally agree with that. I don't know what the
she is a potential witness.
this one is completely speculative about what would happen, and I don't know if that is going to, if they, listen, that could happen in any case. They could call a prosecutor to stand. They wanted to try to do it before, and they didn't, at the end.
That's the lead detective there. I mean, the lead prosecutor there. That's Ms. Bradley.
You can call prosecutors to stand, not necessarily. You can call them to stand, and it doesn't require refusal.
And now you might be wondering why she is sitting here in the courtroom while they're arguing about whether or not she should be allowed to prosecute the retrial. It's because she asked the judge to leave. She said, "Your Honor, can I leave?" And the judge says, "No, this is all about you. I want you here in the room listening to this. Sit your ass down." The judge would not let her leave.
So I think at this point, there's not enough.
Everybody be nice to Della. Come on. You're better than that, chat.
Because you call a prosecutor to stand, or more than one prosecutor to stand, that doesn't result in automatic disqualification.
We have
I
a
care.
law that basically says attorneys can't be both advocates and witnesses. They're in bar rules, and if you, the better practice is for somebody to be reassigned and get out of the case if they're going to be a witness in the case. That's nothing new. It's been around for years. And we have something where, in this case, defense counsel has listed Ms. Bradley as a witness. And whether or not she's...
That's what I said. I just said it with a little more vim and vigor.
But, they've listed her as a witness. And there's an issue regarding multiple Brady notices that went out. So if she is called as a witness, how is she going to argue, for someone's credibility and basically to dispute or say that whatever Ms. Boutros said, that Ms. Boutros is not credible, and Mr. Moretti is, Detective Moretti is credible, or something along those lines. I just see that as being an issue. I don't know how to resolve it.
Well, at this point, I respond to it's collateral or extrinsic evidence, no question of disability.
How's that collateral? It goes through his credibility, Detective Moretti's credibility. That's not
extrinsic. You're looking to determine whether or not it's admissible.
I always read some free chat whenever I can.
Cross-examine each of you. There's other things you can. And in this particular case, there's no right now. There's no crime. So whether or not those things are going to be admissible or allowed is one thing. We haven't even gotten to the point where is there Brady? We didn't get to that point. And add to that, again, okay, I understand, I get it. I get it. Of course,
what do you mean we didn't get to Brady yet?
Pardon?
What do you mean we didn't get to Brady yet?
There's no determination by the court as to whether or not that one statement, which remains the same in all three of the last three that are filed in 3 notices, is what Detective Moretti allegedly said to the deputies. It's the same. Every single one is the first. No one, I don't believe that the first one of the evidence is before the file. That was back on August 30th. Then there were 3 after. And it's the same thing. That's the Brady. And is it material? Does it meet all the 3 problems of Brady? That has to be decided, because if it's Brady, one has to make a decision what it's going to do. They haven't been going to decision. If it's not Brady,
how is it not Brady?
The problem, that's why all of this is a problem. Because if it's not Brady, that's for the state to decide, right? The state always, people don't like it. That's what the Supreme Court said. The state is considered not Brady. And if it turns out at the end it's not Brady, then the state would have no obligation, at least under the rules of according, right? You have to turn it over. So that's why today I just thought we were going sort of in reverse. The cart was in front of the horse. We were sort of going toward the Brady issue.
If the judge wants the cart in front of the horse, the cart is going in front of the horse, dude.
As is can't stand.
Anything else? Anything else from
Just briefly, the case law seems to be very clear that the state attorney's office can continue a prosecution if one of their state attorneys is a witness. but I found no case law that says that a state attorney can be a witness in a trial in which that state attorney is trying the case. I don't believe it exists, have not been able to find it. So therefore, we start off with the rule of whether the state can still prosecute, and the answer is yes, unless we get to this level of what I've been talking about institutional, I don't want to use the word corruption, it's not, institutional prejudice. And I think we can establish that if we have these other witnesses. But as to Miss Bradley, which is what you've been dealing with, yeah, there's a good chance she's going to be called as a witness, because I don't know what Moretti is going to exactly say about these things. I don't know whether it's going to contradict what Ms. Boustro said, and Ms. Bradley certainly could be there to either bolster what Ms. Boustro says, contradict what Ms. Moretti said, because she has had personal conversations with Moretti, and that may become evidence at trial. There's a good chance she gets told.
Anything else?
No.
Thank you. So, Counsel, I'm going to defer rule and take it under advisement, motion under advisement. I understand that you want me to reopen it regarding other witnesses. I understand that. You're not having asked for a continuance. You want to go ahead with your trial, and we're going to do that. But we have several motions that are pending. You be prepared to go forward on the motions. State should be prepared to go forward on the motions, and we'll see where it goes. Well, I'll let you know sometime today. All right?
The reason I'm asking around is
I understand why you need to know.
I need to know this.
But I need to think.
No, I understand. But I need to get notices out to them because they're not going to accept anything that's not within 5 days. So I got.
Aren't all the whoever you need for the motions to suppress, aren't they all under state subpoena? Would they be available?
Well, those are the motions to suppress. They may be.
Yeah, because there was a flurry. He was not kidding. There was a flurry of motions filed. I believe there was 6 or 7 motions filed in the last 2 days to suppress this, to quash that.
We have several motions in limine, and then we have the motions to suppress evidence.
Understood. I have a list of them. So, you talk it over with the counsel, you tell me which ones that there's some agreement as to what you want to have first, who the witnesses are that you need, their availability. And what my understanding is, because the case is set for trial, I would have thought most of the witnesses are available. I could be wrong on that, but that's what I.
Well, they're being available and being made available to us are 2 different things.
And there are no subpoenas out in the state for next week. This is pre-qualified for the notification that any witnesses should be available. I need an opportunity to get whatever witnesses are needed for these various motions. And we're at 24, and I think now 27 that have been filed by defense. The state has a couple of other motions that I'm trying to get filed. However, I was.
Bish, you are on the hot seat. Let someone else do the talking
So
for you.
there's definitely some time that we need to do on that. We have until October, my timeframe, 21st, to begin jury selection and to start that process. My suggestion would be that we set aside time for motions to begin next week and try and get those handled, because it is inappropriate to try and pick a jury.
Okay, it looks like they're going to push this back a week or so. Jury selection was supposed to start Monday.
A week, 10 days ago, but you all told me that we wanted to start with the jury, pick a jury, and go on Fridays. That's what I was told.
That's what defense said. The state suggested that we should do the motions first on that.
All right, regardless, you talk it over and see what you can resolve and which ones you want to have first. I'm gathering that you want to have the motion to dismiss her first.
Yes.
All right, any objection to that?
But I believe we have a date for the motion to dismiss. It would be the other motion.
Excuse me, I'm asking you to state if you have any objection to that.
No, the motion to dismiss is currently set for October 20th, Your Honor.
That's not good enough. Yeah, you've got plenty of time to discuss it. We need to move it up. This needs to get expedited.
Can we take a 2-minute recess?
Sure, we'll be in recess for 10 minutes. Thank you.
Okay, they've got 10 minutes. The judge has given them 10 minutes to talk amongst themselves, see if they can come into an agreement on how they want to handle that. It sounds like the prosecution wants to is suggesting to bump this back a week so that they can argue motions during the next week and start with the jury selection a week from Monday. We'll just have to see how this goes here after the break. But first, oh my gosh, it's 42, 52, 02. It's been almost 30 minutes since Renee I did this on purpose, by the way. The $2 super chat. Read this now, or I'm gonna Christine Chubbuck. No, we're not going to talk about Christine Chubbuck. Google it if you want, but yeah. Sorry, Renee Rip. Oh God. And Enchilada's unbreaded $10 super chat. We appreciate your time. Darcy, spoilers. Come on, man. Or woman, depending if it's a male Darcy or a female Darcy. Spoilers. All right. Yeah, she's trying to run and hide. She did. She asked if she could leave, and the judge says, "Nope, you're the lead prosecutor. I want you sitting here and listening to this." The defense wants them all to leave forever. So, all right, let's fast forward here till they get back in and see what we have coming here. Scrolling. Coming back in court. And go.
We were talking amongst ourselves on what we would suggest we didn't talk to.
Yeah, we left the board to regard to see what they're applying when same time.
Well, when I left, you indicated you wanted to hear the motion to dismiss first.
I think the motion to dismiss should be heard first.
Do you have any objection then?
No.
When do you want to hear it?
Next week.
Done next week. What day next week?
That's too far down the road.
So Judge, we, as the defense speak with the proposition, I guess Mr. Aronson could communicate on behalf of the defense what we would suggest.
We have that 5-day notice that we have, so we are basically precluded from what I can tell anything next week on that motion.
Who do you need to call as a witness? Who do you need to call as a witness?
Miss Bradley, Miss Boutros,
The two prosecutors.
And we probably could adopt some of this testimony we had today. I'm not trying to be redundant, but we're going to need Ms. Falk, we're going to need Mr. Killoran, and we're going to need Mr. Pryor.
Okay, those are the people that are in the prosecutor's office.
Subpoena them first thing Monday, but if you allow it to be heard on next Friday, you're really not upsetting the 5 days other than a few hours.
May I suggest something that the state tell us when they're available sometime next week, and we'll work around their schedule. I know they're very busy individuals. And if they could just inform us when they're available, we would do that motion.
That was like a semi-little snide comment there.
That motion, we're going to have to go and revisit the motions to quash and for protective order.
You gotta hear something first, dude. You wanted the motion to dismiss to go first.
So if you're trying to remedy this argument by the state that we didn't give them adequate.
Counsel, I guess the concern I always had is the time frame is one thing. The other issue is how you get around, how you are able to call Mr. Pryor, I guess, as a witness. I have my own concerns as to how you do that with the elected state attorney. I guess I have to revisit exactly what you put in your motion as to why they use this dismissal, but I thought it had more to do with the failure of the state to comply with its obligations.
The motion simply is the state failed to provide Brady. Normally, the remedy for failure to provide Brady is a new trial. However, there comes a level of prosecutorial misconduct in which due process is violated. That dismissal is the proper remedy. One of the ways that you get to dismissal is by the fact of showing that it's an institutional defect, basically, institutional prejudice. That's what we're trying.
And that's in a nutshell what, and we'll talk about it next week, the motion to dismiss. That's it in a nutshell. They had this prosecutorial misconduct. They violated his rights. They didn't turn over the Brady information that they should have. So where that would normally warrant a mistrial or a new trial, here they have a situation where it's an institutional thing, and the mistrial and the improper behavior has prejudiced to the point where there cannot be a trial. So they're asking for it to be dismissed outright. I don't think it rises to that level. Now, if this was after jury selection had started, they might have a better argument that the prosecution's conduct caused the mistrial, which would give them much better grounds for saying it should be dismissed. But we're kind of in a limbo thing here. So I think it weakens their position just a little bit. But we'll talk about that next week. So he just kind of basically summarized why they're arguing for a mistrial.
That's what we're going to be trying to show. So that is the focus.
Institutionalization.
That does not answer your question as to whether or not we can call Mr. Pryor or not call Mr. Pryor, but that is what the focus of the motion is. As far as calling Mr. Pryor, I don't see, as they say with Donald Trump every day, he's not above the law. Mr. Pryor is not above the law. He has germane testimony and evidence and information that pertains to the operation of the state attorney's office as it relates to this Brady motion, as it relates to the Brady evidence that was not given out timely for the first trial and that we just received. He has information as to what he has told his underlings or the people that work for him and whether that was followed. If it wasn't followed and he allowed it to go by, that also can be looked at as institutional. So we have the right to find out what he did, who he said what to, all the circumstances. And it's not really our right, Your Honor. It's your right also. You have the right, the duty to know all that is going to transpire so that you can make a fair determination of whether the case should be dismissed or not. And the only way you will know all that is by us calling these witnesses.
If I could just interject one thing, Jeff. Ms. Bradley testified that she had meetings with Mr. Pryor. The pleadings on the Brady notices said, and Ms. Boutros said, that she told Mr. Pryor what Detective already said, that he said these things, but it was a joke. But then she changed her mind in the Brady things. If he's a fact witness as to what Ms. Bradley told him, yes, Mr. Moretti told me that I said it, but it was a joke. That puts him right there in the middle of what was said to Your Honor in a Brady filing, and that there was perjury made by she and Mr. Moretti. So it goes right to the heart of it. They alluded to you a few minutes ago. Oh, we don't know if it's Brady yet. So, we have to file a case law that says that any impeachment evidence such as this is Brady. They sat him for a year. In that year, if Ms. Bradley said to Mr. Pryor, here's what Moretti said, and Mr. Pryor didn't do anything about it when he was notified back in October of 22, I believe that this is one of those rare instances where the elected state attorney is a witness. And that's why we wanted to call him. That's why we still want to call him. That's why we think his evidence, if we believe that's what he's going to say, goes right to the heart of our motion to dismiss.
He was the one that was yelling at the judge yesterday.
One is first, and the other one is Logan versus State. And all the reason I'm bringing them out for is in these cases, various state attorneys testified in hearings such as these. So, in fact, here in the Hearst case, 18 Southern 3rd, 975, 2009, the prosecutor, David Ritter, testified at the evidentiary hearing that he never talked to Anthony Williams about his cases and that he never made any promise to him ending the case. I bring that out only to show that the prosecutor testified in these types of hearings. In Kittman versus State, 90 Southern 3rd, 794, 2011.
Well, it was yesterday
At
for
the
me. It was this
evidentiary
morning
hearing,
for everybody
Assistant
else.
State Attorney Victor
The
testified
previous
that he
stream.
was unaware of Detective Cosper's handwritten notes of his interviews with David Pounds on June, blah, blah, blah. What I'm pointing out again, Your Honor, is we can call these people as witnesses if they have evidence that is germane to this issue.
There's no carving out of the elected state attorney is any different than anybody else in his office. And I know it's delicate because.
If the judge lets it happen, it's okay. He could tell one of them to do it, but the main problem is for the court reporter. So if the court reporter's cool with it.
Special about it. And we respectfully request that we need to hear what he has to say. Because you can exclude it after you hear it. But I think what he has to say is gonna be very germane and relevant to this.
Respectfully, counsel, you have no idea what he's going to say.
I believe he's gonna say, based on what Ms. Boutros done, and she told me on the phone that she testified to in the court, that he was told by Ms. Bradley that, yeah, Moretti told me he said this, but he only meant it as a joke. If she said that back then, and then all of a sudden changed her testimony in the latest Brady notice, it shows that she's complicit and is not telling the truth either. And that's why she should be thrown off the case. And I know Your Honor hasn't ruled yet, but that goes to the heart of the impeachment testimony and the heart of the prosecutorial misconduct in the case. We believe, based on what Ms. Boutros said and was a part of in that office, that she changed her story and told Mr. Harold Pryor, Moretti told me he said it, but it was a joke. And then she changed her whole thing, and why did Killoran file this Brady notice that said, just what I'm telling you, that was said. Yeah, he said it, but it was a joke. Where'd that come from? Out of thin air? And then she filed something. I mistakenly said this to, I forgot the exact word, some ridiculous word of I'm changing my testimony now, and Moretti never said it. Where she then admitted that she said it to Mr. Pryor, but now says she did.
Right.
That's not relevant to this case. And I'm sorry, just because he's the elected state attorney doesn't mean he shouldn't be held to the same standard.
He should be held to a higher standard as the
and
other
held
prosecutors.
To the standard of telling the truth about hearing the statement from a prosecutor who either lied then or is lying now. Because it's evident that she, in her own words, said, I said something, but I didn't mean it. She's a trained lawyer. She misstated the lead detective in the case, admitted that he tried to have the guy commit perjury, but then she mistakenly meant somebody else said something else. That's preposterous. And it should show you that we, in good faith, need to ferret out what really happened. Because it's both
It's ferreting out again.
in various Brady notices that change her story.
Hold on.
Yeah.
All done.
Well, let me start at the report. First concern is good. I mean, because the state attorney, but it's case law dealing with the fact of overreach from the list, from the judicial branch onto the executive branch. I need to do research on that. It's the process. You're right. There are issues sometimes with the overreach of the judiciary pulling into the executive branch. That's a case they cited. It sounds to me as though maybe it could have been a 3.85. I don't know. Please, offhand of the gentleman was citing to the court, but it sounds as though the testimony in that case was 38.50. The issue is getting messed up because Brady, right? It's got to be material. And also, Mr. Pryor was not there when the alleged Brady statement was made. Ms. Falk was not there. Mr. Pillar was not there. They were not there. So you're saying, well, we're trying to bring these people up. What if they have nothing but hearsay? And then on top of that, look, if you take that hearsay and the office has to, investigate or to make decisions on Brady, that's all, again, there we go back to work problem. Because how are you going to turn materiality? You've got 100 lawyers in the room. show this to them, 50 will say, oh, that's not Brady, and 50 will say that's Brady. Because there's not a great understanding of what materiality is and how you make a determination on Brady. So,
Counsel, respectfully, when I hear something about evidence going to the credibility of a lead detective in a case, that to me is important, and that's material.
Yep.
and that may well be, but if you, strict Brady standard, you have to look at the whole thing and determine whether or not that was, there's a reasonable probability, if that had been presented to the jury, that it may have either caused an unfair trial or may have changed the verdict. And that's, that's a lot. That's all the speculation. You might not like what you've heard, but presented to a jury, if it's even, admissible, presented to a jury, well, they might take it into account, they might not. It's not like, okay, the Brady material was a video that showed that the defendant absolutely wasn't at the crime scene that night. Somebody else did it.
But isn't that missing the point as to what a jury's gonna do with the information? That the point is that the jury gets the information.
Yes.
That the jury, the defense gets the information, that they have a choice as to what they do with it. If they think
That's
it's
the point of
material,
Brady.
Based upon what it is, that they can present it to the jury possibly. They can make a decision as to that. That's what Brady's all about, is just you turn over what we have very liberal discovery rules in the state of Florida, and there's a federal case talks about turning over those types of evidence. It's always been, as far as I know, that when credibility is and impeachment are in question, that's covered under Brady. Those types of information, that type of evidence is covered. If you have something that shows a witness isn't telling the truth or something along those lines, that's Brady material, and that needs to be turned over. At least that's my understanding of it.
Well, I mean, my understanding is, you have to meet the materiality standard as that put in.
The fact that the lead detective
Possibly the outcome that was
falsified an affidavit and encouraged another police officer to lie under oath
That I agree with.
that he was someplace he wasn't.
That's one of the, or it can be interpreted, does it cast a light on it that you can't be comfortable or confident in the verdict?
So we're getting a feel. I guess the question really is whether or not, assuming that they subpoena the key people in the office, Ms. Falk, Mr. Kilrin, and Mr. Pryor, and you file your motion to quash again, what is the viability of that, and what should my ruling be? I ruled this morning, not the same issue. This has to do with disqualification of the state attorney's office as well as that, but I didn't hear, and I know you're arguing about prejudice. There's no actual prejudice, and that's, so you wanted me to strike the whole motion. I didn't. I let them put on what they want, and I know they didn't put all the evidence that they thought they needed in here, but I didn't see how we got to allow Mr. Pryor to testify at this point. Because it's just
Mr. Pryor is the state attorney for Broward County.
Said that Ms. Boutros or anyone else said that he orchestrated some type of cover-up or told somebody not to testify or don't do this. I didn't hear anything like that. And I heard testimony from Ms. Boutros, who is the main witness regarding this topic, as well as Ms. Bradley. So I don't know where this goes, respectfully. And so what I'd like you to do is you give me some type of short brief. You go ahead and subpoena your people for next Friday hearing. I'm going to tell them if they get subpoenas out, and then I'll hear the motion quash. Let's say on Tuesday, but you get the briefs to me tomorrow, on Monday. Is that enough time for you to do something?
Sure.
Is that enough time for you?
We're going to get the subpoenas out before out on Monday, or we're going to still be in the same issue they're going to say.
No, I'm telling you, I'm shorting the time. And if they get a service, they do it. Let's just get it done. I mean, this is not something, I'm not ruling on the motion of your proposed motion to quash the subpoena, but I understand it's coming. I just want this to move along in some type of reasonable manner. Is that all right?
I will get you on Monday, we.
Yeah, short break.
Short memorandum with our reasoning for why the court's granting this.
That's fine. Then we can do something at the same time, why I should allow Mr. Pryor and the powers that be, the state attorney's office to testify. I'll have that chance to do it. We can talk about it on Tuesday, and then just tell Mr. Pryor and Ms. Falk and Mr. Killer that there's a possibility they could be subpoenaed. The subpoena process is ongoing. There might be a hearing that their testimony would be required on Friday, but I haven't made that decision.
And would you like this short brief by the close of business on Monday or?
That's fine. Close the business. Is that good for you?
We follow whatever the court says.
All right, so we get it on Friday and we'll do it, or excuse me, on Monday. I misspoke, I apologize. And we'll set something up for a hearing. It's Tuesday, or you need one, do Wednesday?
Oh,
Is that all right?
All right.
No idea what our schedule is like. I know they're supposed to be here, but I don't know where I'm supposed to be. I think we're okay. Well, I can be here Tuesday with you.
So that's as to this motion, that's the plan. And then what about some of these other motions? We have 13 motions to suppress. I know we have a couple of other motions. How are you going to handle those?
With regards to the runner, there's a couple of different options. We can look at if we're going forward on those on the week of the 16th. My suggestion is set 2 or 3 each day so that we can be adequately prepared for them. Some of them may not require testimony on each individual motion. Maybe they do over the testimony on the motions to suppress sometime on like the 6th.
Aronson, does that work for you?
Your Honor, as I said, I'll make anything.
So assuming that's the case, now what happens if I grant defendant's request that you're out off the case, Ms. Brett? Who's coming to come in and take over?
We'll address that if we have to, Your Honor.
Pardon me?
We will address that if we have to.
On that issue, Your Honor, we don't want to play around. We anticipate calling Ms. Bradley in our case.
Counsel, I think you made that clear to me before. I've said that at least.
I just want to make it very
3 or 4 times that I received a notice, and I know.
So yeah, the judge is still talking in theoretics. Okay, what happens if you're not on the case anymore? And that's, now he's just saying, look, we're not playing around anymore. She's being called as a witness regardless. And the judge's like, yeah, I know. So it sounds like Bradley, it sounds like she's going to be off the case. Well, we'll have to see how it goes. But it sounds like the judge is asking them to prepare.
Counsel suggested he wasn't aware of it, but I received a witness list that she was going to be a witness. And when I say a witness, I'm talking about your case in chief. That's what your intent is.
Yes.
Yes.
That was made clear.
My suggestion on that, you will, everyone go through all the short memorandum on that issue.
That's fine. You can do it the same if you want.
Thank you.
Anything else to discuss now?
What are we doing Monday?
Nothing.
What are we doing Monday?
All right.
Nothing.
My understanding is you want to hear the motion. Let's just make sure we have a batting order. You want to hear the motion to dismiss? That's going to be heard on Tuesday. You're going to have a memo.
All right, Tuesday's a big one.
By Monday, 5.
Tuesday is the motion to dismiss. So we'll bump back Johnny Depp sidebar reading in favor of this.
Actual motion to be next Friday, because we need those witnesses.
Tuesday's the motion to quash.
Right.
Your Honor stated.
Correct.
That is correct.
I apologize. You're right. You're right. I misspoke. So the motion to quash will be, there's nothing new in your motion to quash, correct? It's going to be the same basic argument, right? You'll get that out, and you're going to go ahead and get your subpoena. So that's on Tuesday, right? You'll have the memos on Monday by 5, And then the motion to dismiss is on Fridays, is that correct? What date is that?
Can you do that after that? Is there maybe the motion to quash Tuesday?
I'm just asking you what date you're doing. So we're talking
Okay.
about, Tuesday, the 10th is the motion to quash. When are we having the motion to dismiss?
I said Friday?
That's why I thought the council saying.
All right, so change the motion to dismiss is going to be next Friday. Perfect for a fucking Friday stream.
Yeah. They attorney, and state attorney, I mean, they got incredible. Yeah. Very important.
So you're saying Friday would be better? All right. So
Thankfully,
Friday.
it's Friday now.
All right. So that's the 13th on the motion to dismiss.
Oh, Friday the 13th.
On
How,
the motions to suppress
what?
and the motion to a couple.
It is Friday the
motions on
13th.
pending as
Sweet.
well. We're gonna start those on the 16th. Is that correct?
So that would be, state's suggestion would be that just based on the number of them, 3 or 4, between each day, Monday, Tuesday, and Wednesday.
Do you need different witnesses for these?
There are so many of them, I haven't even fully reviewed each one in depth. There are some that would require other witnesses on that.
think OJ
And
tank rat.
the state also has motions that I've been trying to file, that are been here, so I have to get those completed.
But on the 16th, so you're gonna start with motion to suppress on the 16th.
Correct.
So which order do you want to have the motion done? Which one goes first?
We'll have to go through them, and I'll see which ones we can have the most witnesses in common. So we can go through that. I do not have them with me, nor do I have my tablet to be able to pull them up individually.
Judge, Ms. Bradley will speak with me, not in court, but off, out of court. I would be happy to speak with her to try to arrange scheduling which motion should go at what time.
Does this help you now? If I have a list of the motions here as well as my checklist as to what motions are pending that I understand it. If you can go through this, would that assist both of you now?
Your Honor, I think we need to look at the substance of each motion and determine which witnesses and if the state will need the additional witnesses.
So the answer is no. You want to talk with counsel and then tell me
Yes.
there's going to be, let's say, 3 motions a day? Is that fair?
I think we need to do at least 4.
And Your Honor, some of them will be easy to do more than 3 in a day, because some of them are just facial challenges to the affidavit, and some of the motions in
LC Merritt, Friday the 13th, evening time US is fucking Friday time. Don't miss that. Don't miss it.
How many you should do? You'll just agree on which ones you can get done in a day, and we'll do that.
I'm happy to do that via email with Mr. Aronson, and it can respond in that way so that there's a record of it.
Fair enough?
Yeah, I like the old fashioned way of talking to people, but okay.
We'll do it by email.
So, but I just need to get it done. I want everybody to I want to have a hearing set on these things. So you'll do that, arrange that, and then send out the notices of hearing.
Yeah.
Travis, can you give us a notice of hearing on the ones that we talked about today?
All right.
Motion quash, when they're.
I think we can pretty much shut this down at this point.
They're going to do the 2 memos.
The important thing is that the motion to dismiss will be held on Friday the 13th. That's also the F at Friday. So we'll do the morning, we'll do the motions, and then Friday evening US time, we'll start the F at Friday stream, or we just say, fuck it. And we have a great panel of guests on. We grift for drinks. We get liquored up and have a good old time on Legal Vices. So everybody stay tuned for next week. We'll be doing a Maritime Monday stream on Monday. A current incident involving a Chinese submarine. Tuesday and Wednesday, probably more Johnny Depp, Amber Heard sidebar readings, or dramatic readings. And Thursday is OJ Simpson Day. Friday will be Melly Motion, and F it Friday. That's next week in a nutshell. Do not miss this. This Melly thing is off the hook. They've pushed everything back at least a week, probably 2 weeks, while they unintercourse themselves and get through all these motions. And Fun Dying with member for 12 months for a whole year. Thank you so much. This whole thing is a bigger pile of crap than the quad flusher I dropped earlier today. Oh, I'm so happy you made me read that. These defense lawyers are good though. I do like these 2 new guys. especially stocky dude. He's getting after it. Old red line. The thing that gets me is the witness tampering investigation that set this up. Oh yeah, we need to set aside a day before Friday to do some more Melly stuff, to get to all the stuff we didn't get to earlier. Which see, this is kind of what happened. They filed the defense filed a motion to dismiss, and very, very shortly after that. Now you remember YMC. I'm so old there. YNW Bortland was out on bail. He was out on a bond. Well, he's not out on a bond anymore because they recharged YNW Melly, and they arrested and put Bortland back in jail, both on charges of witness tampering. And the defense is arguing that's just retaliation. We file a motion to dismiss. They bring more charges against the defendant but both defendants. They bring Bortland back in and recharge him. And then we get this motion to recuse all the prosecutors. So it's been a lot of back and forth motions. I told you there was a lot of updates. There was updates to updates we had to get to. But this turned into a whole thing that took 2 days, and not 2 days for me anyway. And instead of the 30 minutes I was expecting, as someone mentioned just a minute ago, YNW Melly season 2 is lit. This is going to be a phenomenal trial, I believe. So everybody tune into this. Don't miss the trial when it gets underway. We've got the motions coming up at the end of next week, probably the beginning of the following week. They're expecting 2 months for jury selection. 2 months. And it's not helping that all this is going out there as well. So it should be around mid-December, about the time the trial starts. So we'll have to see how that goes. Stay tuned. And Old Red Line says, OMG, Elaine's voice is Bradley. But Your Honor, he said it was a joke. It was a joke. Right. Oh, yes, it was a joke because he said it was a joke. Every time someone quotes Elaine, I hear it in Jeff Simpson voice. Right, there we go, folks. That's it. We're done for today. We'll see you all on Monday for Maritime Monday, talking about the Chinese submarine incident. And in the meantime, if you're really, really, really lonely and really, really want to get your Lorax legal vices fixed, head on over to Rekida's stream, because that's where I'm going to be heading in a few minutes. Hang out there for a short period of time. Then I'm going to go about my weekend. So everybody, mods, and by mods, apparently I mean Flux. I think Flux was, we get, what did we have? 400 or 500 people here. And Flux, I think you were the only mod here. Alan was here earlier. I saw that, but it seems like you've been holding down the fort pretty much by yourself for quite some time. Flux, thank you so much for being super mod. Oh, Alan is here. Okay. Sorry, Alan. Didn't mean to diminish your role. Alan and Flux holding down the mod fort. Thank you so much for doing that. Chat, the Vice Squad chat is the best chat there is. Hands down, no question. We'll expect to see y'all here. Thank you guys so much for the support. Let's head on over to Rekida and see what's happening. Love you all. Lorax out, saying whatever you do, enjoy your legal vices.